Yes. Hi, Vivian. Yes, you can hear us. Okay, great. Thank you. We'll start in 2 minutes shortly.
Le micro, il est ouvert?
Oui, il est sur la table. Ouais. Mais je le coupe pendant les pauses.
Ah, ok, d'accord. Ok, bon.
Voilà.
Donc, on passe à l'anglais. This is nicer than just speaking to a screen, actually. Last year, we had in-person sessions, but I think we also did one over Zoom, right?
Yes.
I think I did one over Zoom. Yeah, I really did enjoy that. I can't say that this year I enjoyed it any more than last year. It's still quite a bizarre situation. Okay, so now I need to move here so that people can see me. Okay, so welcome all, and in particular the ones who made the trip to Brussels for this class. Today we're going to speak about the intersection between Article 102 and IP. So essentially, last time around, I already gave you sort of a snapshot about of what we would be talking about. And today I will go through.
That's fine.
Let's see, press the arrow.
Just double click on the
slide. Okay, let's see if it now works. Yeah. Ta-da. So Article 102 and intellectual property rights. So I guess by this point in time, everyone is familiar with Article 102, which prohibits what? No one knows what Article 102 prohibits? Yes, no volunteers. It prohibits abuses of a dominant position, which obviously begs the question, what is a dominant position? And I've put there the boilerplate definition of a dominant position. In the seminal United Branch judgment of the Court of Justice, the judges said that dominance is a position of economic strength enjoyed by an undertaking which enables it to prevent effective competition being maintained on the relevant market by affording it the power to behave to an appreciable extent independently of its competitors, customers, and ultimately of consumers. So not a particularly useful definition for any purposes, because obviously then it raises more questions than it solves. What is the ability to behave independently of competitors, customers, and consumers? In fact, I don't think anyone has ever come across any company that would be able to behave independently pretty much of everyone. Not even state monopolies. They're still subject to some pressures. But that it is. This is the traditional dominance, definition of dominance, a dominant position. We all know that in reality, how do competition law agencies, how do courts determine, establish dominance? What is the most important element, unfortunately, of the dominance analysis? Again, I'm going to have to start calling people out by their name. I don't know their names. Market shares, right? Essentially, it's all about market shares. You define first a relevant market, a relevant product market, relevant geographic market, then you ascribe market shares, and if the share is above a certain number, you kind of presumed dominance, and what's that number? Yeah, no, that's fine. You, the young lady with the glasses, do you have any idea what the number is above which generally companies should start to worry that it might be found to occupy a dominant position because it has a certain share of the market? What's the percentage?
Are you talking to me?
Yeah.
Okay, yeah, I think it's 40%.
Yeah, exactly. So no dominance has been found below 40%. I think there's a case in which it's found, or no serious case, right? 39 point something in, I forget which case, Donair or, but that's it. And then there's a presumption above 50%, a rebuttable presumption that company has shares above. So that's for dominance. And then once you have established dominance in a properly defined relevant market, you have the need to determine whether a certain type of conduct is abusive. What are the types of abuse? We went through them very briefly last time. So intellectual property and the law on abuse intersect how. Before we get into that, there's a few observations that have to be made, specifically with regard to intellectual property. The first is that there's a difference between abuse of a dominant position in relation to IP and abuse of intellectual property rights. That's a legal notion from IP law and the laws of different countries, different European EU member states will generally also provide for types of conduct which are considered abusive under IP law, but it has nothing to do with abuse of a dominant position under competition law. It's just a term which has been used for a really long time, abusive IP. And we shall see how they may even intersect. Another observation that I made last time around is that the mere ownership of IP cannot be challenged under Article 102. So it's not about owning IP, it's about exercising the IP. And finally, there's no presumption that just because you have IP, you have market power. And last time I explained why that is the case and what the fundamental difference is between a monopoly in the IP sense and a monopoly under competition law. If you have IP and you want to apply Article 101 or Article 102 to agreements or to conduct, you still need to look at it as you would any other type of conduct and start by defining a relevant market. And only once you've done so, will you be able to determine whether the owner of the IP has any market power, whether it's in a dominant position. So no difference between, intellectual property and other types of tangible property. I also told you that the application of the Article 102 prohibition to forms of exercise of intellectual property had gone from being rather exceptional under EU competition law to much more commonplace and even frequent. So the last decade, or even decade and a half, I guess I wrote that sentence possibly 8 or 9 years ago. So going on 2 decades, the last decade has seen a marked increase in the number of cases where competition authorities, and most notably the European Commission, have taken the view that the exercise of valid IP would be an abuse of the dominant positions. And there's many reasons for this. Deficiencies, etc., with the patent system. We need to enlist competition law to help us fix all of these problems. And competition law is a really powerful tool. And then companies also started to realize that once you use a powerful tool of competition law, and in particular of Article 102, you might be able to devalue IP for which you would have otherwise to pay. In other words, to obtain lower prices for IP owned by others. Now, there's a whole list of potential types of abuse, and some of them will have been found in one or a very limited number of cases. Others are more common and seem to make more sense. Starting with the quintessential type of abuse linked to intellectual property, and that would be a refusal to grant a license. A company in a dominant position would refuse to grant a license to someone, and that someone would argue that that refusal is abusive. And this line of case law started with litigation involving car parts, so not particularly sexy, and has then moved on to the much sexier realm of technology, IP, high tech. Then we have excessive royalties as a potential abuse, and in that case, there's no refusal to license, but there's a claim that the royalties, meaning the price being asked for a license to IP, is excessive, reaches the excessive pricing limit of Article 102. Again, we'll go through some of these cases. Then you have potential discrimination, again, because Article 102 prohibits abusive discrimination, treating things that are equal differently or vice versa. So these first three types of abuse are the types of abuse that you also find with regard to other types of conduct not relating to intellectual property. Instead of a refusal to grant license, you have a refusal to deal, for instance, refusal to deal with a rival. Excessive royalties is essentially the application of the excessive pricing prohibition to the price for IP. Discrimination, again, is self-explanatory. Then you have one which is actually only possible in the context of IP, and that's an abuse of the patent system. We have one case involving drugs, pharmaceuticals. AstraZeneca, which was found to have abused a dominant position by making certain false statements or misrepresentations to patent authorities. Another potential type of abuse is exploitive tying. Again, only one case, Duales System Deutschland. We'll go over that. A few more cases that are quite sui generis and that one is unlikely to find out, to encounter in real life. Licensing restrictions that create barriers to the entry of rivals. There's a couple of cases on this, not infringement decisions, but rather Article 9 commitment decisions adopted by the European Commission. Then for good measure, I also included a really old case of an abuse relating to the unlawful acquisition of a company which owned what was considered to be an important license. And then the cases that have in fact generated the most abundant literature on the topic over the last decade. The enforcement of standard essential patents encumbered by a friend commitment. We'll go over those, starting with the Commission's decisions in the Samsung and Motorola cases, and culminating with the decision, a judgment by the Court of Justice of the European Union in Huawei ZTE. A patent ambush case. I will also describe briefly what that is. The Commission continues to insist that Article 102 would apply to the type of conduct that can be described as a patent ambush, although there are very good reasons to be suspicious of that claim, but it continues to find its way into notices and guidance provided by the European Commission. And finally, and this is Esther's topic and hobby horse, pay for delay cases. And I will just say a few words on those. The SCPs and the patent ambush relate to standard essential patents. We'll have one session just devoted to the question of standards. So I will only introduce the topic today, and pay for delay, again, that's for Esther in more detail. Right. Is this clear? Anyone have any questions? I just listed the cases we have, the theories of harm, and essentially most of the examples of cases at the EU level. So Commission decisions and rulings by the Court of Justice of the European Union. So starting with the first type of abuse, refusal to license, as I told you, it all began with cases that related to car parts. And so two seminal cases, Volvo Vang and Renault Maxicar. Essentially, what do these cases involve? Well, the car manufacturers had certain design rights over car parts, right? Like doors or fenders. So these elements of the car, these parts, were covered by IP, and you had independent either spare parts manufacturers or garages who wanted to be able to offer repair services and spare parts at a lower cost, lower price than the car companies themselves. You know, you had a Volvo. Instead of going to Volvo to have your door replaced, you could go to a garage and you could get a door from someone else. Except these spare parts were covered by IP, and so Volvo could actually object. And Volvo, just as Renault later, did not want to grant licenses to these third parties to be able to supply those parts. They wanted to, you know, essentially keep these profitable after-market services to itself. Eventually, this all ended up before the court, and the court made some very important statements on this relationship between IP and competition law. Starting with the notion of the subject matter of the exclusive right. And so the court said the right of the IP owner to prevent third parties from manufacturing and selling or importing without its consent, meaning without a license, products incorporating the design, in this case, the IP, constitutes the very subject matter of this right. And then it said that an obligation imposed to grant, so compulsory licenses, an obligation imposed on the owner of the IP to grant third parties, even in return for a royalty, a license to supply these products that incorporate IP, would mean that the IP owner would be deprived of the substance of this exclusive right, and a refusal to grant such a license cannot in itself constitute an abuse of a dominant position. But then it goes on to say precisely the opposite. And it says that, however, it must be noted that the exercise of an exclusive right may be prohibited by, as it was then, Article 86, now 1. So clear as mud. The right to prevent third parties, the right to exclude, is the very subject matter of the IP right. You cannot challenge it. The refusal to grant it cannot, in and of it, to grant a license cannot, in and of itself, constitute an abuse. But actually, if you do it because that's the exercise of IP, it may be an abuse of a dominant position. And in this case, it started. The court, essentially began to indicate that certain types of conduct relating to this IP could be found abusive. And it mentioned the arbitrary refusal to supply spare parts to independent repairers of the garages, the fixing of prices for spare parts at an unfair level, or a decision to no longer produce spare parts, although there would be cars in circulation of the model for which there would be no spare parts available. So those could be abusive. This is the beginning of the case law on refusal to license. In certain cases, and it gave the examples which apply to the case, to the matter before the court, the refusal to license design rights for spare parts could be an abuse. Subsequently, already in the 90s, we have the McGill case. And this one considered something just a little bit sexier than spare parts, TV listings. You're all too young, I guess, to be familiar with the notion of TV listings. But once upon a time, if someone wanted to know what was on TV, one had to look up in a magazine or a newspaper a listing of the upcoming programs. Sometimes, if it's in a daily paper, it would be just for that day. In a weekly paper or magazine, you might have the listings for the whole week, sometimes only for a few channels, sometimes for all of the channels that one could watch in a given country. Now, these listings, which essentially just a list of programs, were in Ireland protected by copyright. And the TV broadcaster owned the copyright. In Ireland, it was RTE, which means Radio Telefís Éireann, something, Irish Broadcasting Company. And this is why this case is also known as RTE. Mr. McGill, who lived in Ireland, he wanted to have a comprehensive guide for the different broadcasters. Each broadcaster had copyright over its own listings, and they did not allow him to supply this weekly TV guide. So eventually, this all ended up in court. The Court of Justice said that the exercise of an exclusive right by the proprietor may, in exceptional circumstances, involve abusive conduct. So why was this refusal by the broadcaster to allow Mr. McGill to have a license so that he could publish his little guide? Why was this abusive? Well, it was abusive in light of three circumstances. The court said that these listings, which again, covered by IP, in this case, copyright, these listings were the only source of basic information on program scheduling, and that this was an indispensable raw material for compiling a weekly TV guide. And so the refusal by RTE to provide this information by relying on its copyright prevented the appearance of a new product. The new product was this weekly guide, which RTE did not offer, and for which there was potential consumer demand. Third circumstance, by refusing to license, the broadcasters were reserving to themselves the secondary market by excluding all competition on that market, and finally, that there was no justification for such a refusal. And this has been known as the McGill criteria. So, indispensable input, refusal to license the indispensable input prevents the emergence of a new product. So this is known as the new product limb, and unsatisfied potential consumer demand for the new product. And then the conduct allows the dominant IP owner to reserve to itself a secondary market by excluding all competition. The case law that emerged from McGill was subsequently, and not much later, almost a decade later, clarified and supplemented again by the court in the IMS Health case. So, what was this case about? Very, very briefly, a US company which was active in many countries in Europe, called IMS Health, was active in Germany. It provided data regarding the sales of drugs, pharmaceutical products. These data were very useful for pharmacies, drug companies, doctors, etc. And it compiled and analyzed this data by essentially dividing Germany into 1,860 little bricks. That was it. It was known as the 1860 brick structure. Essentially, it divided the territory into 1,860 small little divisions. And this had become a sort of de facto standard in Germany to analyze all of these things. It had a rival. The rival also wanted to treat and provide services that required examining the data relating to pharmaceutical sales. This company, NDC, wanted to make use also of the same essentially organizational dividing structure. So, this doesn't come across as really, really important IP. In these cases, there was a suspicion that was quite evident that the adjudicator, the courts or the commission, didn't really think that these things ought to be covered by IP. The spare parts for the cars, just design. Why would you need copyright over TV listings? And then in the IMS Health case, why would there be some IP covering simply the division of Germany into a bunch of small different areas? So that's one important observation to make. I'm sure you're all familiar with the expression that bad facts make for bad law, right? That the adjudicators tend to hone in on the bad facts and then to try to punish those responsible by distorting, sometimes extending the law. This seems to be, again, one of those cases. So long story short, NDC wanted a license so that it could provide these services also in Germany. IMS Health said, we're entitled not to do so. Essentially, they brought proceedings in Germany against NDC, accusing them of infringement of their IP. Meanwhile, NDC complained to the European Commission. The European Commission took on the matter, adopted a decision that ordered IMS to grant licenses for this structure to all third parties. IMS went immediately to the Court of First Instance, as it was known then, now the General Court, and asked for interim or interlocutory relief. The court looked at the Commission's preliminary decision, interim decision, and decided to stay it. And meanwhile, the Frankfurt court in Germany was dealing with these infringement proceedings brought by IMS Health against NDC, also very confused as to what was going on. And in these circumstances, is asked the court in Luxembourg for a preliminary ruling to clarify the law so that it could know how to rule in the case pending before it. Is all of this clear? Any questions? So IMS had the IP. It wanted to prevent NDC from infringing its IP. So what does it do? It goes to court, asks the court to prevent NDC from doing so on the basis of its copyright. That's how we end up with a ruling by or a case before the Frankfurt court, and then in parallel, NDC goes to the European Commission and argues that what IMS Health is doing, including by going to courts to enforce its copyright, is an abuse of a dominant position. So the Commission adopts an interim decision saying, prima facie, the conduct by IMS going to court seeking to block is an abuse of a dominant position. And the court in Germany also has to adjudicate on the injunction request by IMS. So what does the court in Luxembourg say? It goes back to the language found in Volvo Vang, Maxi Car, McGill, and reminds us that the exercise of an exclusive right by the owner may, in exceptional circumstances, involve abusive conduct. So it's known as the exceptional circumstances test. Then it clarifies the circumstances or the conditions already found by the court in McGill to give rise to abusive conduct. And it says that for the refusal by a dominant IP owner to give access to a product or service that is indispensable for carrying on a particular business to be treated as abusive, it is sufficient that 3 cumulative conditions be satisfied. So again, essential input, indispensable input, 3 conditions. They must all be present, they're cumulative. The refusal prevents the emergence of a new product, so the new product test remains. The refusal is unjustified. The refusal is such as to exclude any competition on a secondary market. So again, the idea that the dominant company is reserving to itself an adjacent or secondary market. It is seeking to extend its dominance from one market to a secondary market. In this case, the primary market was the market for the licensing of the IP relating or covering the 1860 brick structure. And then the market which IMS Health would have been trying to reserve to itself would have been the downstream market, which was the market for the provision of these services that rely on the data compiled on the basis of the 1860 structure. So the court said, importantly, that there was no need to identify actual separate upstream and downstream markets. An hypothetical market for the IP would suffice. This was important in this case because IMS Health has just said, well, there's no market upstream on which I'm dominant, and then which I will try to leverage in order to exclude competition on a secondary market. There's no market for this IP. It's my IP. I don't license it. I use it myself. And the court said, no, it suffices if there's a potential upstream market. You could potentially license this copyright. There would have been a market for that, and that's enough for the purposes of the application of this refusal to license case law and for the exceptional circumstances test to apply. Importantly, the court also clarified that the company that requests the license should not intend to limit itself to duplicating the goods or services that are already being supplied by the dominant IP holder on the secondary market. So this was an important clarification, and this is linked to the notion of the emergence of the new product. So one of the 3 cumulative conditions. The new product cannot simply be a copy of what already exists. If that's the case, there would be no abusive refusal to license. All right, any questions on this so far? Does it seem clear? Or so this is the exceptional circumstances test. Set forth clearly for the first time in McGill, right? The exercise of an IP right may, in exceptional circumstances, involve abusive conduct. Clarified then in IMS Health a decade later, in particular with these useful statements about what the new product test means, whether the conditions are cumulative or not. And then finally, I've put in here for good measure a Microsoft decision. And this is the last word from the court, but not from the higher court, not from the Court of Justice. This is a case by a ruling by the lower court, the Court of First Instance, as it was known, now the General Court. Why? Because this decision, or this judgment, was not appealed to the Court of Justice by Microsoft. And you may ask, why was it not appealed? So I'm already telling you, there's a commission decision against Microsoft. The commission decision found in 2004 that Microsoft was dominant in two markets for PC operating services and for workgroup server operating systems. Not particularly interesting, but there was some IP involved. That IP was some protocols which were indispensable for workgroup servers or operating systems to interoperate with the Windows PCs. So essentially, the Windows PCs are the small machines on the desktop, the workgroup servers are the big machines at the back, right? That's kind of the idea. Found to be two separate markets. Microsoft was dominant on both. Companies that wanted to, for instance, go to a company and say, oh, we'll provide the big machines at the back, and then the big machines at the back, they have to be connected to the machines on the desktops. Well, in order for that to happen, they would have needed to be licensed under some IP owned by Microsoft. These were known as interoperability protocols that were covered by a form of software patent protection in the United States, and I guess something akin to copyright in Europe. So this was a decision by the commission, found that Microsoft had abused the dominant position because it wouldn't license these things to its rivals, and Microsoft appealed it to the General Court. The General Court confirmed the commission's decision, and it said, I'm applying this McGill IMS exceptional circumstances test, but in one important element, it deviates significantly. And that has to do with this question of whether the refusal by Microsoft would be abusive if it does not prevent the appearance or the emergence of a new product. You recall that I said that the new product could not simply be a copy of existing products or services. And in the Microsoft case, this became rather important because maybe a case could credibly be made that what Microsoft's rivals were going to offer was essentially not a new product, but simply products that competed with Microsoft without being new on the workgroup OS server market. And the court, faced with this, essentially said that the circumstance relating to the appearance of a new product, as in McGill and then IMS, cannot be the only parameter which determines whether a refusal to license IP is harmful and abusive. It says that maybe suffices that the conduct limits technical development. So it did a sort of run around the new product requirement. It's unclear today whether this is good law, given that this is a judgment by the lower court. It was never appealed by Microsoft. And you may ask, why did Microsoft not appeal that decision? Well, Microsoft did not appeal that decision because, and this is my understanding, you can't repeat it to anyone, that Microsoft was told that it would not be in its interest to appeal the decision to the Court of Justice, and that this was a commercial, strategic calculation by Microsoft not to do so, which is rather unfortunate because we would all like to know whether this limitation of technical development would have been also accepted by the Court of Justice. as a refinement of the limb of the exceptional circumstances test relating to the emergence of a new product. Another, or rather a helpful finding in the Microsoft ruling by the General Court is that it may be possible to argue as a defense that to grant a license to a third party might have a significant negative impact on the company's incentives to innovate, and that this might be a justification. So a refusal to license would be prima facie abusive because it would satisfy these exceptional circumstances test and all of its three cumulative conditions. But then the dominant IP owner could say, wait a second, but my conduct is justified objectively, because otherwise, if I were to be required to grant licenses, this would have a negative impact on my incentives to innovate. I would not devote the same resources, let's say, to engage in expensive R&D, because there would be the risk that once I've done so and once I have valuable IP, then someone would come along and say, you now need to grant me a license. Otherwise, you'll be abusing the dominant position. In casu, so in that case, the court found that, in fact, Microsoft had been unable to prove that by being required to grant a license to this interop, these interop protocols, that it would have suffered such a consequence, meaning that it would have impacted its incentives to innovate negatively. So is that clear? Does anyone have any questions about how this works? The refusal to license IP and its different elements. No?
Professor?
Yeah.
I have a general question.
Yeah.
I want to know if maybe in any case has a IPR has been considered essential facility?
No, not as such. Not as such. But in these cases, that refusal to license, the IP has been considered indispensable, right? An essential input for a company to compete on an adjacent market.
Okay, thank you.
That's a good question.
I think by some people, these are regarded as the essential facility cases related to IP vote. But
yeah, but that would be wrong. Yeah, that would be wrong. So.
Yeah, but so it is possible that.
It is possible that someone, yeah, it's possible. It's possible that someone will say, yes, that this is an essential facilities test, but it's not. Just as Bronner is not an essential facilities test. So the next type of abuse, less interesting than refusal to license. This one is rather basic, the excessive royalties. You all know that Article 102 prohibits excessive pricing, that this is somewhat controversial, that other legal systems, including the American legal system, the Sherman Act, does not prohibit excessive pricing. Charging a certain price that would be deemed too high is not considered an antitrust offense. And there's very good reasons for this. Why? Anyone venture a guess? Why is it somewhat controversial? Why is it counterintuitive? In fact, why does it make no sense to prohibit charging excessive pricing as an abuse of a dominant position? Because the standard definition of a dominant position is what? Market power, right? The power over price, the power to charge whatever you want. If you simultaneously say that it's fine to have a dominant position, it's the abuse which attracts liability, it's the abuse that is condemned, but then you go on to say that charging excessive prices is an abuse, this is circular. You're in a dominant position because you can charge whatever you want. And therefore, it could not be an abuse to just do precisely that, charge whatever you want. In any case, unfortunately, under Article 102, excessive prices can be considered abusive. And when they apply to IP, you'd refer to them as excessive royalties. What is an excessive pricing? Well, the standard definition in the case law is to be found in the United Brands judgment. This is known as the United Brands test. The price is, you must all be familiar with it, excessive when it has no reasonable relation to the economic value of the products supplied. Once again, another of these court-made definitions that are not particularly enlightening, because then this begs the question, well, what's the economic value of the product supplied and what's a reasonable relation, right? What are the orders of magnitude? And more importantly, how does one go about determining them? The judgment also says that you look at, there's many ways to look at, the reasonable relation. There's many ways to look at, the value. You look at costs. You look at comparisons with prices charged by other companies for similar products. These are not particularly useful in the IP context for a number of reasons. The first is that if you go about trying to determine whether the value of IP is too high by reference to cost, you're going to be obviously misled, because the cost of producing IP tends to be zero. If you're going to go about comparing the price charged for some IP with the price charged by others for similar IP, you're also going to be in trouble. Why? Because the IP tends to be unique. So you won't find or easily find IP that is particularly similar. And then if you're going to determine, assuming that you've looked at the cost, what a reasonable rate of return would be on those costs, you're going to run into the problem that when a company is determining the price it's going to charge for IP, what will it do? It will also seek to recover the costs involved in a bunch of failed projects that never resulted in any valuable IP. And you can think about pharmaceutical companies, for instance, right? That's the textbook example. For a pharma company to be able to patent one drug, it will have failed miserably in its attempts to find new drugs that came at great cost. So whenever it patents something, it also expects that the value of sales of that patented product will cover all of this sunk investment that essentially went nowhere. And that's the same thing for patents covering wireless communications, pretty much everything. If you're in the high-tech fields, in order for companies to maintain the incentives to continue to invest in research and development, etc., they must hope that once they invent or discover something new and valuable, they can sell it for a price that will also cover all of those investment projects that it essentially went nowhere. And that's why it's so difficult then for also someone to say, well, I think that to charge more than X is too much. And that's the reason why competition agencies have traditionally been very, very reluctant to apply the excessive pricing prohibition to IP, because it's difficult, because this would be difficult to satisfy the United Brands test, and also because it can give rise to all sorts of problems, reducing incentives to innovate. However, there's been a few cases. There's one case that I put here, it's a very old case, a decision, an infringement, Article 7 infringement decision adopted by the Commission in the Hilti case. This had to do with nail gun cartridges. You know what nail guns are? You know, those little things like a pistol with guns people used to staple things. So Hilti made those nail guns, there were cartridges, and then there were nails. And all these elements were covered by IP owned by Hilti. In the United Kingdom, so these were covered by patents. And in the United Kingdom, these patents were covered by what is known as a license of rights, which essentially means that the patent holder would be able to pay a lower patenting fees if it said that, well, my patents are available as a license of rights, meaning that anyone who wants to take a license will be allowed. I commit to granting licenses to these patents. And there was a process then to determine if there was a dispute regarding the price, a process for a third-party determination of this price. Well, two rivals of Hilti, Eurofix and Boco, wanted a license to be able to also manufacture these guns, these nail guns and these nail gun cartridges. And essentially Hilton said, sure, the price is X, and they thought, well, this is too high. Eventually, the Commission found that it was abusive for Hilti to have asked for a certain price for a license to these patents. It ended before the court in Luxembourg, and the court said that it had become evident during the proceedings that Hilti had demanded a fee that was approximately 6 times higher than the figure ultimately appointed by the controller of patents. So this would be the adjudicator that would arbitrate a certain amount, a certain royalty in the case of a dispute concerning the amount. So 6 times higher than what was considered reasonable by the controller of patents in the United Kingdom. And the court went on to say that a reasonable trader, as Hilti claims to have been, should have realized that by demanding a fee that was so large, it was essentially abusing a dominant position. So it's unclear whether the court finds that there's a constructive refusal to license or essentially an excessive pricing case. It didn't really matter for those purposes. There's been a few other important cases. There's one that lasted 4 years before the Commission, an investigation into Qualcomm, in which the question of excessive prices or excessive royalties was probably one of the key elements. The excessive pricing prohibition or excessive royalties abuse is routinely raised in litigation before the courts of member states, in IP infringement proceedings, in cases where there's a duty to license. We will see that this becomes an issue in the case of standard essential patents. It doesn't obviously it obviously is not an issue when there is no duty to license. If a IP owner is under no duty to license, essentially, it could charge an infinite price. So the excessive pricing provision would not apply. Again, now one of the more curious decisions, and this is part of a couple of Article 9 commitment decisions, so decisions by the Commission that don't find an infringement, and in which the company under investigation offers some commitments essentially that are accepted by the Commission to make the case go away, sort of settle. Two similar cases that were adopted or that were pursued in the wake of the financial crisis in 2009, against when competition agencies all over Europe had a particularly powerful incentive to be seen to be doing something against the financial institutions that would have caused the Great Recession, and which has resulted in a few particularly weird cases. One of these is the Standard & Poor's case. You all are familiar with Standard & Poor's? I hope. No? They've been accused by many people of being essentially single-handedly responsible for the Great Recession. Right? What do they do? Does anyone know what they do? Amongst the many things they do?
It's a rating agency.
Yes, they're a rating agency. So they were rating products, including CBOs for subprime mortgages. I guess you're all too young to remember the financial crisis of 2009. So Standard & Poor's was seen as one of the, it was vilified as one of the, if you've watched the movie, what's it called? Well, both Margin Call and The Big Short, right? There's a part where the rating agencies are described and how they couldn't care, they got everything wrong, didn't have the right incentives. Well, right after that, the European Commission decided that it was going to go after Standard & Poor's, but not for its ratings, for something completely different. Standard & Poor's was responsible for, was the national numbering agency for certain territories with regard to ISINs. ISINs are, it's an acronym. It means International Securities Identification Number. It's a system developed by the International Standards Organization as the standard 6166, for the identification of securities. And securities are like stocks in any market. Sometimes you refer to a ticker. The ticker is like a bunch of little, letters or sometimes alphanumerical characters in long form that identify a share, some stock being traded on the market. So maybe if you're familiar with financial markets, you will know that Google, or whatever it's called now, Google has the ticker G, and that Apple has the ticker AAPL, Apple, or that Ford Motor Company used to be F. And then to identify the exchange in which they're traded, you'd have maybe a little dot thereafter. That would be, for instance, G dot, if it's traded in Euronext in Amsterdam, it might be G dot AS dot something. This allows someone to know exactly what is the security being traded. Identifies the company, the exchange, et cetera, et cetera. So rather straightforward. Standard & Poor's was in charge of this. They were the national numbering agency. As it turns out, these things were arguably covered by copyright. Standard & Poor's claimed that it had copyright over essentially this list of alphanumerical characters. And so it licensed them to financial institutions and whoever would need to make use of them in their business. In Europe, S&P was the national numbering agency for all of the US ISINs. It distributed them, it licensed them in Europe for a fee. The commission said, well, the prices you're charging for this are too high. The commission simultaneously took the view that the ISINs were not covered by IP in its view, as a result of which, in fact, no one should have taken a license, and that it was covered by IP, as a result of which the license fees could be too high because it compared the fees with the cost of maintaining and of producing the ISINs. We won't know much more about this because the case was closed following S&P's decision to essentially abolish the licensing fees that the financial institutions paid for the use of the ISINs within the EEA. But it's a fun case. The interesting part for me is that if the commission was right and there is no IP, then there was no reason for any banks to ever have paid anything. They should just have run the risk that Standard & Poor's would never be able to enforce its IP before any court. And this was simply not factored into the assessment. But the assessment is very short. It's, you know, essentially in Article 9 commitment decisions, what you have is a short description of the preliminary views of the European Commission. So the preliminary findings regarding the existence of an infringement of the competition rules. And again, they're preliminary. Now, a much more recent and much more interesting case dealing with excessive pricing is to be found in the Latvian Collecting Societies case. And if you're familiar with competition law, you will also know that there is a rich and abundant strand of case law that deals with collecting societies going back many, many decades. I hope you're familiar with the notion of collecting societies. You know, these are the organizations that tend to manage copyright at a national level for, well, it varies. Copyright on works of art, musical productions, music, that sort of thing. In France, there's a SACEM. In Belgium, there's SABAM. If you want to play music to the public in any club or bar, you need to pay a license fee to SABAM in Belgium, right? Well, there's one in Latvia. It has a really complicated name with many consonants. I won't try it. Case before the Court of Justice. Again, the question which has arisen in every such case is whether the licensing fees that the collecting societies charge to allow others to play music, for instance, in public spaces, or for, you know, TV broadcasters to make use of the repertoire managed by the collecting agency is too high. The court said that for a licensing fee to be excessive, it must be both significantly and persistently above the relevant benchmark rate. So in this case, it was essentially a cost comparison. The important part is that the court found that for the excessive pricing prohibition to apply to royalties, the price has to be both significantly and persistently above some benchmark with which it is being compared. The court also added that even once you've established that the price is significantly above a cost benchmark, that it is merely indicative of the existence of an abuse, and that other elements have to be present, and in particular, that they are subject to an efficiency justification or an objective justification by the undertaking concerned. Advocate General Wall, in the opinion rendered in this case before the Court of Justice issued its ruling, made perhaps even more important points. The first was that excessive or unfair pricing as an abuse could only exist in regulated markets. Why? Because, for this very reason, what I alluded to in the beginning of why the excessive pricing prohibition is in and of itself counterintuitive. So high prices in non-regulated markets are likely to be self-correcting. Once you charge high prices, you attract other suppliers, and eventually, as a result of competition, prices decrease, and then will, in perfectly competitive environment, tend to decrease towards marginal cost. So it's only in regulated markets where there are barriers enacted by the state would you have the possibility of finding that a price is excessive. And his suggestion to the court would be to say that even so, the price would only be excessive if the difference between the price actually charged and then a relevant benchmark would be of such magnitude that almost no doubt remains as to the abusive nature of the price charge, and that establishing a lower threshold would be neither realistic nor advisable. So what he was saying was essentially the court should find that for a price to be excessive, really there can be absolutely no doubt, because the magnitude of the difference between the price that is charged and what we found was a comparator, right, a similar product or a relevant cost benchmark is such that you could have no doubt whatsoever that this is absurd. I'm sure that even if this legal standard were to be adopted, one would still have some difficulties, right? So what is a price? What is a difference of such magnitude? What is 1,000% higher? I don't know, 10,000% higher? Just 10 times higher? It's unclear. Depending on the markets, there could be good reasons to actually have a price that could be several orders of magnitude more substantial. But this is the contribution of Latvian collecting societies to the question.
Can I add something? Maybe it's also important to remember these considerations because they're also very important for the cases that we will see next week on excessive pricing in the pharmaceutical sector. There, I have some interesting examples of what could be significant, where there's really 10,000% higher prices than what would be expected.
Yeah. So there was a case in the pharma sector not that long ago, a few years ago. I forget what the name is of this gentleman who ended up having to go to jail in the United States for having jacked up the price of some drugs, the rights to which he had acquired in the United States for some very rare diseases. And I forget what the name is of the company. And he raised the price by, I think, well over 1,000%. This eventually landed him in jail because, I see I have a visitor, and I think the visitor is indicating that it is time for a little break. Okay, let's have a break, and I guess we can return at, I don't know, 10 to 3 or so. Yeah.
Okay.
Okay, so then I guess what I'll do is that I'll do this in 55 minutes, I guess,
Yeah, I'm just.
so that you have enough,
Correct.
so that
Yes.
Esther can then devote.
But you can take the time that
2
you need,
hours.
because we also still have next week, so if I need a little bit.
No, but I'll leave you to.
Because it's an important topic and it prepares also for next week, no, with this.
Yeah, but no one can go through all the types. Remain the same for longer than 2.5 hours. So now slightly different from excessive pricing, the application of the excessive pricing prohibition to friend rates or friend licensing terms. We will go in detail into standardization and whatnot. I don't know if anyone knows what friend means. If you don't, it means fair, reasonable, and non-discriminatory. Friend is a concept that has existed for a really long time. It's a general concept. It's a useful concept. You can always, it's a concept used in, imperfect contracts. You can determine that a price will be, a future price will be friend, very reasonable and non-discriminatory, instead of having to agree on an exact price. It can be very useful for products that will only be sold in future, or to account for renegotiations, to account for changed circumstances, etc. In this particular case, the friend here relates to the royalties for licenses to standard essential patents. So patents that are essential to an industry standard. For now, suffice it to say that, again, there's been, in the last 2 decades, Article 102 has been used to seek to diminish or to reduce royalties for licenses or royalties provided for in licenses to these standard essential patents. When in the standard setting context, when a company has essentially contributed some of its technology to an industry standard, it will generally say, tell the standard, sometimes it'll be under an obligation to tell the standard, if my technology is included in the standard, and if it is covered by some of my IP, by some of my patents, I will give whoever is interested a license to that technology on friend terms. So in future, when someone wants to make use of it, to make a product that complies with the standard, they will come to me, we will negotiate a license, and then we will determine what is fair, reasonable, and non-discriminatory. And the question has arisen, does Article 102 apply to these royalty terms, to these licensing terms? Is it the equivalent of an excessive price, a price that is above this fair, reasonable, and non-discriminatory benchmark? The most important case is a case actually that was decided, that made its way through the court system in the United Kingdom, and it pitted Unwired Planet, a company that had certain standard essential patents, against Huawei, the Chinese manufacturer of smartphones. Essentially, Huawei claimed that the licensing terms that Unwired Planet had offered it were not fair. Unwired Planet said, if you want to make smartphones, Mr. Huawei, you need to take a license to my patents, and the price is X. And they said, no, that's too high. And then ended up in court. And there was a judgment by the High Court in 2017, upheld by the Court of Appeal and the Supreme Court of the United Kingdom recently. essentially, the court said, and the seminal judgment, the most detailed assessment of all of these issues was essentially carried out by Lord Justice Peirce, who was the judge sitting at the High Court at first instance. He found that a royalty rate would only constitute an excessive price, an abusive excessive price, if it was much more than friend, so substantially more than friend, not just simply above a friend rate, it had to be much, much, much higher, which again reminds us of this issue of a price that has to be significantly and persistently above a relevant benchmark. Now, the next type of abuse is discriminatory pricing. As you know, Article 102 prohibits abusive discrimination. This can also apply to prices. Is a price abusive? Because it is discriminatory. In other words, because someone else is paying less for the same product. The case that deals with this is Mayo. It's a judgment on a reference for a preliminary ruling from a court in my country of birth, Portugal, involving a broadcaster, a cable company, Mayo, and the Portuguese Collecting Society. Mayo did not want to pay license fees to the Portuguese Collecting Society for the right to broadcast works covered by copyright. They claimed that the license fee that had been offered to them was discriminatory because some rival in Portugal would have been paying less. The court said that first, that there is no de minimis threshold for determining whether there is an abuse of dominance. But secondly, and more importantly, that discriminatory pricing would be abusive only when, considering all the circumstances of the case, it is capable of distorting competition generally. So it is not sufficient that you have established that there's a difference in the price relative to what a rival would be paying the company in the dominant position. The discrimination must affect the interests of the operator, meaning that the discrimination is capable of having an effect on its competitive position. In other words, that the difference in price has to be quite significant so that it actually has a meaningful effect on the ability to compete of the company taking the license. Once again, Advocate General Wall had a very, very enlightening opinion preceding the judgment by the Court of Justice, and stated that it should only be possible to penalize price discrimination if it creates an actual or potential anti-competitive effect, and whether this would be substantial enough to have an effect on competitive pressure. In other words, it's not sufficient to say, well, but my rival is paying a lower price. You would also have to show, in order to be able to prove abusive discriminatory pricing, that this difference is such that it will affect one's ability to compete. So for instance, if, let's imagine that I'm paying a license for a technology to make these bottles, and I'm paying 5 to the owner of patents that the patents that cover the production method, and one of my rivals is paying 6, is paying a higher price, right? Now imagine that, in fact, the whole cost of producing this is, let's say, 500. I'm paying a license fee that represents 1% of the final cost of this bottle. And my rival is paying something which is just 1.1% of the final cost. Is the fact that I'm paying less than my rival sufficient to allow me to compete, to have a competitive advantage over the rival who makes the bottles for which he pays 6 in royalties? Seems highly unlikely. No, it's not sufficient. This is what this judgment says, is that the difference has to be significant for this discrimination to be abusive. And now turning to an even, even rarer type of abuse, but now one that is clearly specific to the IP context. So the other ones, the refusals to license, the excessive pricing, if you're practicing, you'd be called to perhaps examine in your everyday work conduct that would fall within one of those types of abuse, even if you don't have anything to do with IP. But for this one, you'd really have to be involved in a field that requires you to look into patenting. And the type of abuse is abuse of the patent system. It's the AstraZeneca case. In reality, there's 2 abuses. I'll go over both of them. The European Commission found that AstraZeneca had committed an abuse. The Court of Justice eventually confirmed, after the General Court had affirmed the Commission's decision. These cases are quite controversial because it's one of the few examples of almost per se abuse that doesn't require proving the existence of anti-competitive effects. At least the legal standard does not. AstraZeneca, as you know, is a pharmaceutical company. They were found to have misled patent offices and courts in Europe in order to obtain what is known as SPCs, supplementary protection certificates. Essentially, this is sort of an extension of the duration of patent protection. As you know, patents traditionally are granted for a period, 20 years. The effective duration of that protection is going to be much lower because of the whole process to obtain marketing authorizations, to put drugs on the market, et cetera, et cetera. And so the authorities have created these supplementary protection certificates, which essentially allow taking into account relevant milestones for drugs, allow an extension of the patent protection for those drugs. In this case, it was for an ulcer treatment drug called Losec. In order to obtain these SPCs, essentially the drug company had to show, well, I obtained approval for the drug only at this day, or at this point in time, and that meant that I already lost a few years of patent protection, and so this should kind of be extended. And then there were some questions about the relevant date, and AstraZeneca referred the patent authorities to the date of the pricing approval of the Losec drug. As you know, many jurisdictions have to approve the prices at which drugs are put on the market. And AstraZeneca used that date, and that date was different from the date of marketing authorization, which is the date in which a drug is authorized to be put on the market. Now, this benefited AstraZeneca because it would mean that the protection would extend further than if they had used the date of marketing authorization. There were some defensible arguments. Eventually, the Commission found that this was abusive. They had done so intentionally. The court of first instance held that it was objectively misleading, that the conduct did not require that the commission show malice, intention, or even effects. So complete per se. Some general statements about the fact that the conduct or the choice of the relevant date might have been legally defensible, which then is entirely inconsistent with the idea that the representations would have been highly misleading. I don't know really what to make of this case. You know, I've never met anyone who was capable of explaining to me how one could have that paragraph, which I invite you, encourage you to read at leisure, in the hope that you can one day discern meaning. I fear that you will not be able to find it. So again, there was a recognition that that might be a legally defensible interpretation of the rules that would have justified AstraZeneca using one date instead of another, and yet, because it used the wrong one, this was objectively misleading. There was no need to show any intention, any malice, any effects. This sufficed to conclude that they had abused the dominant position. So this is for the first abuse. The second abuse is perhaps a little bit less controversial, both found in the same decision against AstraZeneca. And this was not misrepresentations to the patent office, but misuse of the procedures used by the agencies which at the national member state level approve and authorize pharmaceuticals. The commission found in its decision that for the low-spec drug, AstraZeneca had deregistered the low-spec in capsules, so it no longer wanted to be registered for this drug, low-spec in capsules, and had switched formulations. Instead of selling low-spec in capsules, it had sold low-spec as tablets. So it went to the drug approval agency and said, oh, I have here this low-spec in capsules. I no longer want to pay for the fees to have this drug registered. I'm going to register a different formulation, which is the one I will now sell, which is low-spec in tablets. Now, it just so happens that makers of generics that compete with such drugs can use what is known as an abridged procedure, which allows them to bring their drugs faster to market if the marketing authorization for the reference, meaning the originator's drug, is still valid. And what the commission found was that, in fact, AstraZeneca had changed the formulation and asked for deregistration simply to prevent the generic makers, which hitherto were selling their generic product that competed with the low-spec capsule, so that they would not be able to benefit from this pre-existing approval by the drug approval agency. There would be no marketing authorization for them. They would not be able to use the abridged procedure, and then this would affect even import patterns within the EU. The court essentially confirmed the commission's findings. It annulled part of the decision, which had to do with the effect on import licenses, not a key element of the case. So is that clear? So one abuse is essentially lying to the patent office. You don't have to show anything. The second abuse is being sneaky and trying to do certain things that would make the lives of rivals harder by changing the formulation of a certain drug, which is approved for use. Helpfully, the Court of Justice found that the deregistration of a certain drug might be objectively justified where maintaining it is essentially expensive.
Professor,
Yeah.
may I ask a question? I want to know if how was the relevant market defined in these cases?
Was a relevant market defined? Well, I forget. If memory serves, in the first abuse, the market was defined as drugs for the treatment of ulcers, a certain type of drugs for the treatment of ulcers, and AstraZeneca had a dominant position in that market. And I think, as regards the second abuse, it was the same market. And I don't want to say something silly, but I don't think there was any distinction or sub-segmentation or anything made depending on the formulation of the drug.
Okay, thank you very much.
But Hester can correct me if I'm wrong.
We can come back to it next week. Because then we speak much more about pharma, so it's easy. But it was very narrow and hence quite easily a big market share.
Yeah, it was a certain type of ulcer treatment drug.
Yeah, so it was quite specific, so really narrowly defined.
Yeah, and there were hardly any generic rivals, as a result of which the market shares remained above 40% for quite some time. No, actually, no, I forget.
I don't remember all the
I think
specifics, but I can look it up for
Yeah.
next week.
In the second one, the generics were, or there were already significant quantities of generics that were part of the market, but still the market shares were above 50 or 60. I mean, they were very high. Now, a case or a type of abuse you're even less likely to ever come across. There isn't really a better way to describe this than exploitative tying, although I'm not sure that anyone but me refers to it as such. It is also viewed as perhaps a type of unfair pricing. This is a case that concerns the fascinating world of recycling of packages in Germany, outside the public waste disposal system. There was a company called DSD, Duales System Deutschland. They were found to have a dominant position in the market for that. Why? Because there was a German rule that forced businesses to actually arrange for the collection of packages if they sold them. How was this done? Well, businesses could put on their little packages a little green dot, the grüne Punkt, and this was covered by trademark. And then once consumers got rid of their packages, well, the ones with the grüne Punkt would be processed, would be collected by the company that had the grüne Punkt trademark, DSD. But the companies that wanted to use in their packages the grüne Punkt, ensuring that the packages would be collected, well, they had to pay a license fee. That's how pricing was arranged. Essentially, they paid DSD some royalties in order for their packages to have the little green dot. The way in which this was calculated was that they would pay for the trademark for all of the packages with the green dots, irrespective of whether they would then use the DSD package recycling system, because the packages could have also been recycled by someone else. So the fees did not vary with the amount of packaging that actually was collected by DSD. A company could have all of its packages with the green dots, but then in the end, only 50% of it would have been recycled by DSD, and then the other 50% could have been recycled by some other company, collected, recycled by some other third party. Well, some of them complained. They said, no, we don't want this, we want some other mechanism. And the commission agreed and said, no, the license fee in this case for the trademark, for the, that's the IP, it's a trademark. The license fees here, they're actually unrelated to the cost of providing the service. And it's exploiting the licensees who are paying too much. And it's actually preventing rival suppliers of these package recycling services from being on the market. Why would they be prevented? Because if the companies that make packages and it could use the recycling services, if they're already paying, right, someone, they're not going to pay someone else. So that was the rationale for this. I've called it exploitative tie because the case can be seen as a form of tie between the trademark and the product and the collection. It has also been referred to as unfair pricing. It's a very sui generis case, but it was confirmed on appeal by the General Court and by the Court of Justice. It was the hobby horse, unsurprisingly, of a couple of Germans at the commission. Maybe one slow day, someone complained. They said, "We're going to take this on." I was there at the time when the case started, so I remember in DG-Comp when they started to really look into this. It didn't seem to make any sense then, just as it doesn't seem to make much sense now. I've never seen this being, used, referenced, referred to, applied by analogy. Essentially, in 20 years of practice, this has only resulted in confusion. Another type of interesting type of abuse, again, which you are unlikely to come across. This one also concerns financial information and also adopted in the wake of the Great Recession against Thomson Reuters. It was also an Article 9 commitment decision, so no final finding of infringement of the competition laws, but a preliminary assessment indicated that the Commission had taken the view that the company in their investigation had abused the dominant position. So Thomson Reuters had these things called RICs, Reuters, what are they called? Reuters instrument codes. Just like in the Standard & Poor's case, something similar to the ISINs. Also, some little alphanumeric codes that would allow financial institutions, banks, etc., of identifying securities. All of the banks use them. They made use of them in their internal systems. They refer to RICs all the time. It allowed them to retrieve data also from the providers of data to the banks. Companies that have all of these pipelines with all of the relevant data, everything that has been transacted, et cetera, which the banks make use of. And Thomson Reuters was found to be dominant in a market for consolidated real-time data feeds, essentially a market to provide financial information that is useful for banks and other financial institutions. They licensed these RICs. They had come up with them. It's just a clever way of identifying securities, it's stocks, bonds, etc., just like the ISINs. The only difference being that these are proprietary to Thomson Reuters rather than something that the international standard organizations would have come up with. And then the commission, some banks said, well, we don't really like these licensing fees. They're too high. But more importantly, rival suppliers like Bloomberg of these data feeds of financial information, they said, this is a problem because all of these banks, they're already paying too much for this, and if they don't take a license, well, even if they take a license, they can't use the RICS codes when they are making use of our real-time data feeds. This is a real problem for us. It creates a barrier to entry. Because, for instance, Thomson Reuters prevented through its license its customers from actually having tables that would map the RICS with whatever other codes would be used by the rivals. So the problem was, according to Bloomberg, that a number of bank customers were really reluctant to move to Bloomberg because all of their software was based on RICS instruments codes, and if they wanted to make use also of these financial information services provided by third parties, the things really wouldn't work well together because of these licensing restrictions. They couldn't map. You wouldn't know which was which. Thomson Reuters eventually offered some commitments to the commission so that there will be a new license that would resolve these problems, because in exchange for a slightly higher fee, the customers would be allowed to use RICS with the data from Thomson Reuters competitors. So that's how the case ended. A rather sui generis case. The licensing restrictions in case just seemed to increase the barriers to the entry of rivals, but we don't know what a legal standard would look like that would essentially create antitrust liability for this type of company. We don't know what one would need to show, what kind of effects in order for something like this to be considered an abuse. What should you show regarding the extent of these barriers to entry? All right, so maybe I'll skip the generics because I already went through them, and then they will be covered in detail. I mentioned it in the original, in the first lecture. So we'll go to the type of case that has led to the most spilled ink over the last decade. The cases involving the enforcement of standard essential patents. For the sake of transparency, I always end up forgetting this. I've been involved in a lot of these cases, right? I've been, counsel for the parties. I won't, mention all of them, but it reminds me that I was involved in many of them, but that doesn't mean that I'm biased one way or the other.
Not at all.
I was counsel for Thomson Reuters, but also for Qualcomm and also for Samsung. The cases involving standard essential patents, we've already seen. I've already talked about one, but the ones that really kick-started over the last decade, this wave of invocation of the competition law rules in IP were the cases that dealt with the standard essential patents during the smartphone wars. There's been various waves. In fact, there have been 4, and now we're going to get probably to the 5th wave, waves of litigation involving generations of mobile communications standards. If I take out my phone, well, I'm in Belgium, so it's not a really good example. If I were to take out my phone in a civilized country, what would be the generation of mobile communications that my phone would indicate? Come on, it's a simple question. It's not a competition law question.
5G.
5G, good, right? So
I mean, also in Germany.
yes, in the civilized world, we would have a phone that communicates on the basis of the 5th generation of wireless communication standards. In Belgium, we're limited to 4G, maybe forever, because there's a lady who studied, I forget what she studied. I think she was a primary school teacher who decided that her understanding of science was such that she could assert that cell towers, the cell towers that relay the wireless communications, were hazardous to your health at a level much, much lower than that which the World Health Organization had found to be dangerous. In fact, 100 times lower. And that is the reason why every time there's a new generation of communications, there's a big war in Belgium, especially in the southern part. I think the competence is now regional. So, Sean will correct me if I'm wrong. Yeah, but in Brussels, why every time there's a huge hoopla about this? Simply because in Belgium, one lady thinks that this is incredibly dangerous to your health. The WHO got it completely right, but we are all safe in Belgium because of her. Now, this is obviously nonsense. Whatever the case may be, every time that there's a new generation, we started with, 1G, the first generation, the big bricks that people used to carry with them in the late 70s. I'm sure you've seen some movies, things that look like a big carry-on luggage. To today, there's been subsequent generations. All of these have been standardized. And then all of these generations of mobile communications, essentially they are specifications. It's documents that tell you, if you want to have a system now for this 3G, the system will look like this. If you want to have a system for 4G, it has to look like this. They're very detailed, very complex, going thousands of pages. Many of the things that are described there are technical inventions, and many of them are covered by patents, and they're all put together by these very helpful standard setting organizations, SSOs, and then people contribute their technology, and then they tell, if anyone wants to make use of my technology, we'll grant these licenses to these patents, which are essential. Cannot be avoided. If you want to make a product, a system for 4G, you're going to have to use my patents. But I will grant licenses on these friend terms, right? And then every time there's litigation, waves of litigation, known in 3G as the smartphone wars, when the first smartphones came along, before 4G, first generation, second generation, they really weren't very smart. They were just phones. There was only so much you could do with data. You could send some short messages. And then in 3G, 4G, and now probably 5G, you've had big litigations between Apple, Motorola, Samsung, Nokia, and Motorola, Ericsson, and Motorola, Broadcom, Qualcomm. Everyone has been involved. And one part of the litigation, an important part, is essentially been about standard essential patents. They've all essentially sued each other in the hope of reducing the costs of licenses to this standard essential IP. And these two parallel cases, Samsung and Motorola, they both pitted Apple against, on the one hand, Samsung, and against, on the other hand, Motorola. At the time, Apple, still to this day, Apple had never contributed anything to the standardization process. They're not responsible for anything that has happened in wireless mobile communications, except they have developed a very good and revolutionary operating system, which is the main reason why their phone has been so successful. And when they launched their iPhones, they didn't want to have to pay licenses and royalties to anyone. Eventually, they went to war with one of their big rivals, Samsung, and another one, Motorola. In 2007, they launched the iPhone. It implements, amongst others, a 2G standard known as GPRS. Motorola had some patents, a bunch of patents, actually, a valuable patent portfolio because Motorola had traditionally contributed a lot to the standardization of wireless mobile communications. And Motorola told Apple, if you want to sell this iPhone, you need to pay me a license fee because your phone will make use of my patents. Apple never wanted to pay anything. Eventually, Motorola went to a court in Germany because Germany has a good court system viewed by someone as perhaps, patentee friendly. In fact, a system which takes into account, Germans have many, many flaws, as we all know, but they also have many qualities. The patent system and their judiciary are quite good. Probably now the most important jurisdiction in Europe for patent infringement proceedings, with several very, very, highly competent courts in Mannheim and in Düsseldorf. And they also used to grant, and they still grant, injunctions, which is, you all know what an injunction is, right? It's an order essentially telling someone you cannot do this. So in the case of patent infringement proceedings, when an injunction is granted by the court, it prevents the party against which it is issued from selling a certain product because it infringes some patents, some IP. So Motorola went to a court. Eventually, there's litigation everywhere, but in Germany, they sought an injunction. They said, German court, please prevent Apple from selling because they're unlicensed. And during these proceedings, Apple said, it put up what is known as a friend defense. It said, I'm entitled to a license for Motorola on friend terms. And Motorola has never made an offer on friend terms. Motorola's conduct is abusive. The fact that they've gone to a court and asked for an injunction is an abuse of a dominant position. In December 2011, the German court was unmoved by Apple's arguments. In fact, Germany had its own legal standard for this sort of thing. It was known as the Orange Book standard. There's no point in going through it, but essentially they said in order for a company to avail itself of the competition law defense under German law, they need to meet certain requirements, and Apple had not met the requirements. They get an injunction. And then eventually the whole thing is stayed temporarily. Around the same time, Apple was also embroiled in litigation with Samsung. Apple sued Samsung first because Samsung is a big rival supplier of handsets for infringement of a bunch of design patents. You may have read about it over the years. And then Samsung countersued, but Samsung countersued on the basis, again, of standard essential patents. So in Motorola case, it was GPRS, so second generation wireless standard patents. And in Samsung's case, it was UMTS, a third generation wireless standard essential patents. This resulted in many actions being brought all over the globe. And once again, Samsung went to Germany and a few other member states and also asked the judges, please grant me an injunction because Apple does not want to take a license to my patents. Now, what happened here? Well, Apple went to the European Commission, made a big stink and said, well, both Samsung and Motorola's actions, meaning going to a court and asking the court for an injunction in respect of these patents, which are standard essential patents, and in the circumstances where Samsung and Motorola have told the standard setting organizations that they would grant licenses on friend terms, is an abuse. the commission conducted an investigation, and then the commission adopted two decisions. One against Motorola, an Article 7 decision finding an infringement, and an Article 9 decision against Samsung, essentially because Samsung gave certain commitments to bring the case to an end. The commission concluded in both cases that seeking an injunction was an abuse of a dominant position where the injunction concerns then essential patents and there's a commitment to license on friend terms, and the licensee, meaning in this case, Apple, the potential licensee, the company that is implementing the standard, is not unwilling to take a license on friend terms. This was seen as rather controversial for a number of reasons. The legal test was rather convoluted. It spoke about particular circumstances of the case. Until these cases, everyone simply assumed that outside the context of, not outside the context, any practitioner review competition law until that time essentially assumed there would be almost no circumstances in which the act of going to a court to ask for something would be viewed as an abuse of a dominant position. There was one case, ITT Promedia, an old case in which the commission and then later the court, the general court, had actually found that it might be possible in wholly exceptional circumstances to consider that a type of vexatious litigation could be an abuse, but the bar was set really, really, really hard. It was wholly exceptional. There could be no hope in hell for the claimant to prevail. It really had to be litigation that was completely vexatious, just to annoy. No reasonable claim, no reasonable attempt to assert one's rights. So that was, that makes sense, because the ability to go to court is, a fundamental and essential part of the rule of law. If you start to telling even companies that in some circumstances, actually going to court can be an abuse and you can be fined, that's, it's totalitarian. And yet that's precisely what the commission concluded, that in these cases, never mind the fact that the companies themselves, the patent owners, can't do anything. They're at the mercy of whatever a judge decides. So this was, very controversial. Simultaneously, whilst the commission was adopting these decisions, this became even more controversial because the German courts looked at the press releases that accompanied the statement of objections in the Motorola and Samsung cases. The commission issued some press releases. The Germans looked at them and said, this is really weird. We don't understand any of this. This is inconsistent with the way we've been looking at things. And also it will have a tremendous bearing on all of these cases that we have to resolve and to adjudicate. So we're going to the first time we can, first case that comes up and that is right for this, we're going to send a reference to the Court of Justice for a preliminary ruling. We're going to ask the Court of Justice, can you answer these few questions about the proper application of Article 102 to these things? Which they did. And that case was a case pending, a similar type of thing, litigation involving standard essential patents, but this time between Huawei and ZTE. And so the Court of Düsseldorf sent these questions, and the commission, whilst the case was pending before the Court of Justice, and the Court of Justice would come up with the definitive answer, went ahead, adopted these decisions, and then the vice president in charge, at the time Vice President Almunia, competition commissioner, said, I hope the court will take into account our interpretation of the, you can imagine him with his Spanish accent, of the EU competition. Again, something which 20 or 30 years ago would have been considered bizarre, that the commission should have taken this step whilst awaiting the courts to actually provide clarity. An attempt at policy making, legal test that completely ignored this precedent on the right of access to court, an assessment of dominance, which essentially assumed that that the patents being asserted were essential, valid and infringed, and then no effects analysis, no guidance on what friend terms were, etc., etc., etc. I'll go back to this. The commission found that seeking an injunction before a court was, in certain circumstances, be an abuse of a dominant position. It then went on to say that these circumstances are the commitment to the license, standard essential patents on friend terms, and a licensee who could show that it is, and this is a weird formulation, not unwilling to take a license. So the question of what this means, the unwillingness of the licensee to take a license. Essentially, it created a safe harbor in favor of the potential licensees or the implementers of a technology standard, because essentially that meant that owners of essential patents would in all likelihood be very reticent to seek injunctions when they couldn't get to a license agreement, because there was this risk that they would be found to have abused a dominant position. And before I turn then to what the court said, this Huawei ZTE ruling that was pending whilst all of this was happening. Do you have any questions? And I'll understand if you don't have any questions, because the whole thing probably seems quite murky at first blush. And I guess there's no questions either via Zoom. All right. But I will only bore you for an extra 12 or 13 minutes. Whilst all of this was going on, as I mentioned, the German courts had sent a few questions to the court in Luxembourg in the Huawei ZTE case. And they said, how do we apply Article 102 to these things, especially in light of these decisions adopted by the European Commission? And the Court of Justice provided the answers, handed out a judgment in 2015, and essentially created a new type, potentially a new type of abuse. So we shall see. The court said that in the particular circumstances of a case, the seeking of injunctive relief would not be an abuse if the owner of essential patents complies with certain conditions. So we will see what these conditions are, and we will also see what the particular circumstances are. So you recall that the McGill IMS Microsoft test is known as the exceptional circumstances test, right? And it applies to refusals to license. Well, the Court of Justice here realized that the exceptional circumstances test that applies to refusals to license would not apply and would essentially preclude a finding of liability in these cases. What it did was create a new type of abuse relating to IP, which we can refer to as particular circumstances test. And what are these particular circumstances? Well, where the patent is essential, meaning that its use is indispensable to all competitors that want to manufacture products that comply with standards. So that's one assertion. And then the second circumstance is that the owner of these standard essential patents has committed to license them on fair terms. And the court then goes on with a formulation in the negative that in these circumstances, the seeking of an injunction by this dominant patent holder will not be regarded as abusive if certain things are done. The court doesn't say anything about what we thought was the applicable legal standard, this wholly exceptional circumstances under which vexatious litigation can be an abuse. No. The court makes no reference. You won't find any reference in the judgment to this idea that access to court is so important that going to court asking for an injunction should never be considered, or only in these absurd circumstances that can never be satisfied, would never be considered an abuse. And then what are these conditions? So it says, not an abuse if the owner of the SEPs complies with the conditions. Essentially, it looks like this. It's a series of like little steps, like a little song and dance between the owner of this IP and then the company that should take a license. So before bringing the action, the owner informs the implementer of the supposed infringement, and it designates the patents in question. And then after the implementer expresses its willingness to conclude a license, the SEP holder presents a specific written offer for a license, and then it also indicates the royalty amount. And then in the event that the implementer does not accept the offer, then it may rely on the abusive nature. And then it continues and continues and it never ends. And it can be summarized as this. And it's like a child's simplistic view of what happens in the real world with the force of law and in a manner which seeks to micromanage an important element of commercial activity. It's like an attempt at judge-made industrial organization. A court that says which even practitioners find hard to explain at first blush. It says, in these circumstances, if there is a patent owner that has these SEPs, and this patent owner has given a commitment to license on friend terms, if it goes to a court and asks for an injunction, it tells the judge, please prevent this this licensee from selling its products on the market. This will not be an abuse as long as it has done all of these steps, which are our idea of how licensing negotiations for one patent take place. Now, in reality, no one licenses just one patent. There's thousands of patents. This would be a highly complex process. And this is, and this is rather unclear. It doesn't say what happens necessarily if the SEP owner doesn't do any of this. You can follow what happens on the little diagram. Let's see. The next few slides, and essentially this will be the last type of abuse that we deal with today, concern many of the different elements of the judgment, which are open to criticism. The reason they're here is because it is. This is, in my view, without a doubt, one of the worst judgments that the Court of Justice has ever handed down. And the reason it's bad is not because of the outcome. The reason it's bad is because the reasoning is based on demonstrably false propositions. It is riddled with assertions and sweeping statements which are demonstrably false and which essentially betray a misunderstanding by the courts of key elements. And these elements are definitional and foundational. So for instance, the court says the particular circumstances of the case, right? This applies where the patent is essential. And then the court explains what essential means. It means that its use is indispensable to all competitors which envisage manufacturing products that comply with the standard. Now, this is not true. A patent can be a standard essential patent and yet not be indispensable to all competitors that envisage manufacturing products that comply with the standard. More importantly, it doesn't tell you anything about whether the products in question compete with other products in a relevant product market. So it tells you absolutely nothing whether the owner of these patents should be subject to the duties, right, that dominant companies see imposed on them. In Samsung and Motorola decisions, the Commission had taken the position that each patent was its own relevant market, and therefore that each patent conferred on its owner a dominant position. So if a company has 1,000 standard essential patents, it will actually occupy 1,000 dominant positions. It has 100% of the market because the market is the patent. Something quite preposterous. Now, the judgment in Huawei ZTE, it does not address this point of market definition dominance because it wasn't required. It's a reference for preliminary ruling, and the court's role is to address questions being asked. It has to assume elements provided to it by the court of the member state that refers it, including dominance and the market defined. However, the ruling does say a few things which would make us question whether the Commission's position that each patent is its own market and each owner of an essential patent is necessarily in a dominant position, because the court refers to Huawei ZTE having equivalent bargaining power. And why would that be the case? Because in that case, both actually had standard essential patents, which the other Huawei had patents which ZTE needed, and ZTE had patents that Huawei would have needed to license. So it suggests that maybe the court would have some doubts regarding whether Huawei was in a dominant position, and perhaps less keen on assuming that in disputes that involve companies which both have SEPs, that one party would be found to hold a dominant position. Now, courts elsewhere in Europe have concluded that this is not necessarily the case, that the fact that a party has one or several patents, even if they are standard essential patents, does not necessarily confer upon them a dominant position. One has to look at the facts of the case before one, and one has to determine what the relevant market is, what the functions are that are provided by these standard essential patents. In other words, a proper assessment has to be conducted. This part I will skip. The competitive harm examined by or determined the potential competitive harm from the type of abuse is not clear either. It's unclear whether the court thinks that the reason why seeking an injunction may be an abuse is because it may lead to excessive prices, so the exploitation of the licensee, or whether it is because it could result in the foreclosure, so the exclusion from the market of the licensee. Here we have these notions which will, to which we will return, the notion of hold up and the notions of reverse hold up. The allegation being made in these cases of injunctions is that the seeking of the injunction allows the owner of standard essential patents to hold up the licensee. In other words, that this threat of the injunction is so powerful that, let's imagine the case of Samsung and Apple. Samsung goes to court, asks the court to award an injunction that would keep Apple's iPhones from the market. And then the theory goes that the threat of that injunction being awarded by the court is so great that Apple would essentially pay Samsung whatever it wants. So essentially, that's a notion of hold up. The patent holder holds up the licensee through this threat or through the actual recourse to injunction. But there's also the notion of reverse hold up. And the notion of reverse hold up is essentially that the licensee, the potential licensee, the company that needs the standard essential patents to make products, because it can drag out negotiations potentially for years before all courts, raising every single potential argument, will engage in the reverse holdup of the patent owner if at no point a court will actually enjoin it from settling its price. So unless there is the actual threat that at some point the court will say, well, you haven't taken a license, you have infringed these patents, you cannot sell your products. Without that, you would have a reverse holdup. So the company that does not own IP would manage to pay much less than the IP is worth, a suboptimal price for the IP. This would be the reverse holdup. So if you ever come across these two notions, and you will in either judgments or in notices, this is what they mean. Although the court's Huawei ZTE legal standard is rather confused and it's quite formalistic, one thing is clear, and that's that it has rejected the legal standard that was put forward by the commission in the decisions in Samsung and in Motorola, and in particular, this notion of the willing licensee against which nothing could be done. Because it would have been an abuse to actually bring a case against a licensee that has said, I'm willing to take a license. Essentially, that was the commission's case. The court says, no, it's more complicated than that. And that's the end of today's lecture on abuse of a dominant position. It's becoming harder every year to do this within the time allotted. I understand if you are slightly puzzled by all of this, it will not get easier. But on the other hand, if you focus simply on the most important types, you should be okay. Just some knowledge of refusal to license, the terminology, the exceptional circumstances test. If you're aware that bringing an injunction can be an abuse of a dominant position, but that the particular circumstances test is rather narrow, that there is such a thing as making misrepresentations to a patent office, that should suffice. Those are sort of the most important cases, and the other ones that I said you're unlikely to come across, the more arcane, such as the Thomson-Reuters Standard and Poor's cases that deal with these alphanumeric codes, or the Dualis of Deutschland. probably never, regardless of what you do in life, never have a need to think about them or to apply them by analogy or to look them up. So unless anyone has any questions, I will pause here. We can take a 10-minute pause and then give the floor to questions. I hear a question. Yeah.
Yeah, Professor, I have a question. Yeah, because SEP is a very hot topic in China. So I would like to know, in some cases, for example, Huawei or ZTE, they will ask the China courts to give them an anti-suit injunction. I would like to know, in that case, is that anti-suit injunction is indicate that they would not to give a front term?
I'm trying to understand your question. You're saying if a court in China grants an anti-suit injunction?
Yes. So is that indicate that Huawei or ZTE, they do not want to give the counter offer on front terms? Or how to judge this kind of anti-suit injunction? So what is the nature?
Yeah, that's a question that hasn't really arisen in Europe, also in particular because we don't, anti-suit injunctions are an American import. I would think that essentially an anti-suit injunction is an injunction that is a judicial decision that states that a certain party will be prevented from bringing a claim. I'm not sure that anti-suit injunctions really are going to be an issue for EU competition law because the legal traditions of the member states of the EU in most cases would not permit even the filing of an anti-suit injunction. And I assume that even where they would, I cannot imagine that competition law would play a significant role in the court's determination of whether to issue the injunction. In other words, I don't believe that there's an avenue for the for Article 102 to be used as part of the reasoning for granting the anti-suit injunction. I already have a hard time accepting that the seeking of the injunction would be problematic. I just cannot imagine how an anti-suit injunction would also in any way be linked to competition law. I hope that answers your question because I know that obviously in China things will be different just as they would in the United States, but thankfully you don't have Huawei ZTE in China or in, I mean, you don't have the Huawei ZTE legal standard in China as you wouldn't have in the United States. So the question will be presumably different.
Excuse me,
Okay,
I would like to, I have a follow-up question to Vivian's. Couldn't it be Article 8 interim measures be used by the Commission as the quasi anti-suit injunction in cases of abusive litigation, or representations before the patent office?
Well, I suppose in abstract, they asked the Commission could bring interim measures. It hasn't been very successful. And that's why it's a very high bar. That's why it didn't actually adopt interim measures for a very, very long time. I guess between the interim measures adopted against IMS Health and the more recent and then the Broadcom case 2 years ago. So I don't know how long that is. 18 years, I think. That there's reasons why There's reasons why it is so difficult to succeed for the Commission to order interim measures that will pass the interim measures test, right? Camera care. And the test is even less likely to be satisfied if the interim measures are directed at conduct that consists of going to court, right? I just don't see how it would satisfy the interim measures criteria.
Thank you.
Okay.
All right,
There are
if
no
that's it.
further questions. So after the break, we will go into the licenses. Valerie has sent you these kind of sample licenses. They're relatively simple. If you yet didn't have the opportunity to look at it, maybe you can quickly go through it, because the idea is that you will become a little bit more active now and that you work with me on those documents. So try to, so I have them printed out, but you have the electronic versions. So if you haven't yet looked at it, please do so, so you have at least an idea of what this is about.
He's looking at me, asking if it's fine, but I'm fine. It should work.
It's there. It's already there.
Ah, voilà.
You're better than you thought.
Yes, that's true. That's true. Thank you for reminding me this. There we go. Okay, so this is yours. And I don't. Ah oui, j'ai pris le mauvais écran. C'est mieux de l'avoir en. Ah oui. Yes, so there is a question, but it's from Grace. Anyway, if you understand it.
Yes.
Hey, voilà.
Okay, that's the same as always. Okay, so after this very inspiring lecture from Miguel, ending with standard setting. So that is really his thing, his field. He is working on that night and day, and he will continue basically with presenting more on that next week. So next week we will have his lecture more about standard setting, giving you some more details and considerations about the cases that we had and ongoing cases. And I will be dealing with the pharmaceutical sector, where there have also been quite some abuse cases lately, also focusing on excessive pricing, what I mentioned before, but the settlement agreements that were also mentioned by Miguel earlier and also last week. So basically you see a kind of specification or an application in two different sectors of Article 102, but also Article 101. In some of these cases, both 101 and 102 play a role. So we will see more of that next week. But what I also want to do today is delve a little bit deeper in 101 into the technology transfer block exemption regulation and the guidelines. And so last week we also did a sort of round of introduction, and some of you have already some more experience in IP licensing, but also some of you have a completely different background. And because it's good to have at least an idea of what a license is about, what kind of provisions do you find in a license? Because if you need to check the compliance with the block exemption regulation, and you need to have a kind of awareness of the structure of the license. So for those of you who have a lot of experience working with licenses, that may be a little bit simple, but still I think it's useful to do so. And because licenses, as all contracts, are generally confidential, so I have given you 2 sample contracts that are publicly available, because generally companies are not too eager to let their contracts flow around. So these are 2 sample agreements that I shared. And so the idea is that I first still give you, I think it's stuck.
Yeah.
I can also do it here. It's easier.
Just double click on it and then.
Yeah, I can also just do it here. That's simple. Without the clicker. Okay, so now the clicker should work. Okay, so first a reminder. So Miguel and I were teaching this together also, not only to give you the competition side, so your whole LLM is about competition law, but also to let you understand a little bit better the intellectual property challenges. In that respect, I also want to come back to the question of grace that was already put in the chat much earlier, where she's asking what if the dominant company would have trademarks and trade secrets rather than patents, because patents have a limited time of protection. So last week we spoke a little bit about the differences of different intellectual property rights, and indeed for patents it's maximum 20 years. For trademarks, in principle, as long as you are paying, you can extend. As long as you're paying the fees, the maintenance fees of the trademarks, you will have those rights. And so for trade secrets, as long as you keep them confidential, you could have them for a very long time. So the typical example of the Coca-Cola recipe, it's already very old. And so basically there is no limited time of protection. So in theory, that makes sense, saying like, okay, what does that then mean if the company is forced to change into patents? But so that second part of the question makes a little bit less sense to me, because generally certain things you can get patent protection for, and other things you will get trade secrets protection or trademark protection. So it's not that you can be forced into another type of intellectual property rights. It's what you're applying for. And so this is, being forced into applying for a particular type of rights is not really something, a kind of situation that I could imagine would happen. So I'm not sure whether I completely understand that question, but so on the one hand, I think it's correct. There are these different intellectual property rights And indeed, for patents, it's limited. So there's a different kind of requirements also on patent owners, you could say. The rights are different when it comes to trade secrets and the trademarks, but really you wouldn't be pushed in either of the rights. It's just a different type of rights that you could take. So what I tried to emphasize then last time also that it's important to be aware also of the complementarity. So in a lot of these licenses, it's not only about the patents, it is also about the know-how. And so indeed, the license agreement can last longer than 20 years. This is also something that is not necessarily anti-competitive. This was also something that was raised last week by Miguel. He then had a list of potential clauses that are coming from the technology transfer block exemption regulation and the guidelines. And he also said, yeah, most of the clauses that people are using in their licensing agreements, they're not problematic. They're actually pro-competitive because licensing is considered pro-competitive. There's just a few restrictions that could potentially be problematic, but not that a license would be longer than 20 years, because there might still also be know-how that is within the scope of the license agreement. So it's important to understand the differences and the different characteristics of these different intellectual property rights. And also, again, I want to highlight that certain concepts like innovation, dynamic innovation and efficiency are especially potentially tricky, and also the definition of the market when it comes to intellectual property rights, because these are such dynamic markets. So it's actually in practice quite difficult to define markets if there is so much innovation going on, because it's not a static thing. So that may be trickier than in certain other sectors where there's less innovation going on. Also important, and this is also something that Miguel emphasized last week, but a little bit less today. Please remember, intellectual property rights are exclusive rights. So they allow you to prevent others from doing certain things. So the injunction, which was also something that was raised a lot by Miguel, and that he was explaining how are the injunctions being used within the court, within the context of standard setting, how is it being perceived by the Commission? So injunctions are very normal in an intellectual property law, because basically what you're doing is saying, you cannot do this because I have these rights. And indeed, if those rights are granted in line with the requirements of IP law, there's nothing wrong with that. No, because also the rights are limited in time, in territory. So you can also, in a legitimate manner, then ask for an injunction. But the question then is, are there certain special responsibilities in particular circumstances, such as, for instance, with the standard setting context? So the Commission says yes, Miguel says no. He says no, it's not that different, and so an injunction should always be possible. That is not necessarily some kind of anti-competitive conduct. And so what I also want to emphasize in that respect is, so already a lot of IP lawyers use the term monopoly rights rather than exclusive rights. And I think that also explains some of the sort of reluctance or fear of some people by calling it monopoly rights. It makes it something which is almost inherently anti-competitive, which is not really the way that it should be perceived, because these are perfectly legitimate rights. And rights that can be used in different manners and are also used by a lot of companies in a very proactive commercial manner. So not in an aggressive way where you continuously go to court and ask for injunctions. That's sometimes how it is presented to the outer world. But there's a lot of licensing agreements, there's a lot of R&D collaborations, where actually innovation is being shared. It's ensured that there is no duplication of work. So again, really a kind of profit-making purpose. So companies such as Philips are also very well known of really building their business model on a very proactive licensing conduct. So sometimes there's the image is being given that a lot of IP owners are engaging in this kind of abusive conduct, but that is, those are more the exceptional cases. So even though there have now been quite some of those cases in different sectors, as Miguel has also emphasized, there has been an increase of abuse of dominant position cases started by the Commission, also started by different national competition authorities. But if you look at all the collaborations that are happening worldwide, of course, that's a relatively limited number. So it's also important to look at this in a realistic manner, that the abuse of dominance cases are still more the extremes. And the work that people are doing at the interface between IP and competition law, it's a lot more the technology transfer block exemption regulation. It's checking the compliance. That's more the day-to-day practice of IP, and the others are more the extremes. I see that there's some more, it depends on what you're seeking for. Yeah, so this is still the distinction between patents and trade secrets, where indeed Till is emphasizing also that trade secrets are definitely not a kind of solution for everything, because they don't give such a strong position as an intellectual property right would give. So what happens in practice? The products, which is quite easy to observe, and where indeed you could quite easily copy the object once it is out there, once it is being sold. That's what you would disclose in the patent. But other things like your process and other sort of affiliated know-how, that's what you want to keep secret, and that's what you want to protect by relying on the trade secret directive in Europe. And so the two are really complementary, and it's not something where you could be forced in either intellectual property rights. It's a choice, and for different objects, just one type of protection is more obvious than the other. And of course, it also depends a little bit on what type of organization you are. Is it a small, medium-sized enterprise, a large company? Universities nowadays also apply for a lot of patents, but they do that in a very different manner from a company that has a really big budget to apply for IP. So they would use a lot of provisional applications, and then they would start looking for potential partners. They would do not just an IP landscape, but also really be very careful in trying to find potential partners who would be interested in licensing or actually buying the IP, or maybe setting up a joint spin-off company, or investing in that. So they very much rely on collaborations to actually support and find budgets for their IP protection. So their considerations are, of course, different. And also as a company, if you are setting up a license agreement with a university, of course, your considerations are different, and I will list a few of those. Also, in terms of the sector, the behavior will be different. Also, is this a priority? Is this a business priority for you? Or are you rather interested in setting up a more strategic licensing model surrounding that IP? So that is that all distinguishes in how you deal with that. And so that determines both the question, what do you want to protect? So the product, the processes, and also how do you want to protect it? To what extent are you willing to disclose the core of your innovation? And then also, how do you want to exploit it? How, if somebody is indeed infringing, are you willing to actually go to court, or don't you have the budget for that? So that's especially, of course, for small and medium-sized enterprises. Often they are stimulated to apply for protection, but they will not have the money to actually go to court if somebody would be infringing. So then you may wonder, is that then a good use of your resources to spend a lot of money on applying for patents if you already know in advance if somebody would be infringing, that you would never be able to take that company to court because you don't have the budget to do so? And that, of course, it depends a little bit on the country. Not in all countries it is super expensive to do so. But yet, if you're a small company, you may be stimulated to apply for the protection, but then you also need to be able to have an effective enforcement strategy later on, or to have somebody who's willing to support you and to invest in that if you are starting litigation. So that is an important consideration in that respect. And maybe also, last week I explained also the complex situation in terms of the European patent system, where we now have these European patents. So there's centralization of the application procedure at the level of the European Patent Office. So you could still also try to get national patents, but a lot of companies would be more eager, especially if they are active in many different European countries. They would go immediately to the EPO. But then if an examiner has come to the conclusion that all the criteria are fulfilled, patent is granted, you will end up with this national bundle of patents, which means that if you're a small and medium-sized enterprise, or small company, you would need to go and enforce your rights in all those different countries. You need to go to courts in all those different countries. So it may not be expensive or maybe less expensive to enforce your rights in one jurisdiction, but doing that in many, based on this bundle of national patents, will be much more complicated and, of course, much more expensive. So all of that needs to be taken into account. And so the exploitation, the actual use of your IP would be through R&D collaborations, licensing agreements, or assignments or transfer. And here, especially, we focus on the licensing agreements. Also in the TRIPS agreements, there's a legal basis for that. I'll just go over that quickly. And so for entering into a license, there are then, of course, different considerations for the licensor, the licensee. The licensor may not be using the IP at that point in time, so may be interested in raising some additional licensing revenue. If it's a very novel product, very risky, it may also be a way to share the risk with the licensee and to develop the product, to both develop the product further, to improve the product, and in that sense, to share the risk. If the IP relates to a standard, so we go back to the standard setting context, you may actually be obliged to license in accordance with FRAND terms, fair and reasonable and non-discriminatory licensing. It may also be because you're interested in getting a cross license. If the other party, the other company also has interesting IP to offer in return, a cross license may be interesting. And in some extreme situations, there may even be situations of a compulsory license. So for the licensee, so in general, before getting a license, you would check and you would do a freedom to operate. So what does that mean? Your IP experts would make an IP landscape, would check what is the relevant IP. Do you really need to take licenses, or is it possible to invent around the patent? What is the quality of the patents? How big is the chance that if you would challenge it in court, that a judge would say, oh yeah, this patent should never have been granted? If it's a weak patent, that's often the term that would be used in that respect. If it's a weak patent, so the chance is high that if you would challenge it, that a judge would say it is invalid, then you may not want to get a license. Maybe you want to take the risk and say, if the IP owner would come to you and say, okay, yeah, you need a license for me, you could simply say, okay, I don't think your IP is so relevant, or I don't think it is valid. Or you can say, okay, the technology that I'm working with, we invented around your IP, so really we don't need to take a license. It really depends on the strength of the IP. It depends also on what kind of company you are, if you're very risk averse, or if the price of the license is not so high in comparison to the price of your product. then it may be still interesting to take the license. So there's a lot of considerations before actually deciding whether you will take a license or not, or whether you will grant a license from the perspective of the licensor. So what are important points of intention within the context of these licensing practices? Also the affiliates. So especially if you are licensing to another big multinational, it's important to, in the license, to very carefully define to whom are you licensing? Is that only one subsidiary, or is that the whole group? This is also something that is sometimes forgotten, especially also by smaller companies, not the bigger companies, because they have, of course, very experienced lawyers in that. But this is really something that I can recommend you to be very careful about. Also, if you are representing a client who wants to license with a university, I've already indicated there's a lot of special things to consider. Or if you're a company who actually wants to take a license from the university, because often the researchers, they are stimulated to get patents, and it's sort of part of the recognition that they get, but they're often much more interested in publications. So the university wants patents. It's also stimulated by the government to apply for more IP protection, because that they can use that for all kinds of indicators to show that it's a very that there's a lot of innovation happening in the country. So also in universities, you see really increased patenting activity, but a lot of the researchers, they're much more interested in the publications. And so within the university, often they have quite good arrangements. They have agreements with scientists that they would first come to the technology transfer office, inform them, notify them, so that they can file a provisional patent application before they would actually present at a conference. And that's important in Europe because we have a concept of absolute novelty, which means that even if the scientist, the inventor himself, would present at a conference, would present the product that would also be the topic of the patent, then the examiner, if the examiner will find this conference presentation, will say, okay, there's already prior art. So basically the inventor will have destroyed his or her own chance of getting a patent. So this is why it's really important within a university, because there's a lot of researchers, to have good arrangements, but there's also sometimes some mistakes that happen. And when the technology transfer has not been able to keep track of what scientists have been doing, which means that your patent will be not so reliable. So if as a company you would license such a patent, there is a chance that afterwards there will be an invalidation in court. So it's really important that if as a company you're licensing from a university, that you really check whether there were no problems and issues in terms of researchers who have been talking in a public environment about the invention in advance, because otherwise maybe the license that you're getting, and maybe you're taking an exclusive license, and an exclusive license is often involves quite high royalties. It may be less valuable than what you think because of this kind of tension between the interests of the university and the interests of the scientists. Also, really important is there the confidentiality. As I said, often there's complementarity between the patent portfolio and the know-how that is kept secret, but scientists are not always so good at keeping things secret because they actually want to exchange, they want to share, they want to talk about it, they want to improve it, they want to be in big European consortia where they can work together with with companies, with other universities. So also their confidentiality is more complicated if you work together as a company and if you're getting a license from a university. So if you then look at the license, and so in a bit we will look at this sample license agreement with this colorful front page. So what is important is the grant clause itself. So in the grant clause, it is explained what is really the scope of your license, what kind of products are being covered, what is the technology that is covered. Also, does it only relate to patents or patents that are already granted? Does it also relate to applications? So why is it important to check whether it's about granted patents or applications? It's an easy question, but I just want you to also say something and not me to talk the whole time. So why is that important? Maybe the lady with the red jacket?
Actually, I'm a guest.
You're a guest?
Yes.
Okay, so maybe you're a neighbor? So what is a patent application? Why is it important to distinguish between granted patents and patent applications if you're getting a license?
With the application, you never know if the patent is also being granted. So
Yeah.
that would be then subject to a condition. So the entire clause would be subject to the conditions that they will be granted.
Yeah. So applications, so often it takes really long because many of the patent offices around the world, they have a backlog. So it can take, depending on the sector, but in some sectors it takes for about 5 years before there is actually a decision from the patent office and before you know whether indeed the patentability criteria are fulfilled. So you understand that it's in the interest of the applicants to already start licensing if they think it's a very valuable technology within that first 5 years. And it's also possible, there's no law that would prevent you from doing so. But of course, for the licensee, there's a chance that the patent will not be granted. So you take that into consideration in terms of also the licensing fee or the royalty, the height of the royalty that you're willing to pay. And you may indeed want to have some safeguards in that respect that you include, or that maybe if it turns out that the patent is not granted, that maybe at that moment there would be a decrease of the fee or that there would be some other renegotiation possible. Maybe at first phase you think, oh, this will likely be granted, but there may always be hurdles along the way. So it's important to check that. And so often, or in most cases, there will be also an annex to the agreement where it is specified which patents and which patent claims, because often it's not the full patent that you might be licensing. You might just be licensing claim 1, 3, 7, and 9, for instance. And so that's all listed in the annex. So it's very, very specific. You only take what you need and you only pay for what you need. So the material scope of the license is really important. Also the territorial scope, because we know that intellectual property rights are territorial rights. And so I remember, I think last week it was also Simon who said, yeah, but how is that not possible? Isn't this a kind of territorial restriction? Isn't that actually very problematic from a computational perspective? Well, not in this scope, or not in this particular area with intellectual property rights, because the rights in itself are also territorial. It just depends what kind of additional restrictions you would link to that specific territorial scope. So sometimes you will have licenses that are global licenses, but if patents are not protected everywhere, and you only have patents within your scope, why would you have a global license? You would only have a license in the areas where there are rights, because otherwise you are paying for nothing. You're paying for air because there are no rights in those jurisdictions. So you would also very carefully list the jurisdictions where there are rights. And maybe you don't even need a license to all those jurisdictions if you're not active, if you're not selling in those markets. So that's also very important to consider. So what strategically, from a business perspective, are the relevant countries for you to cover in the license? And so also the field of use. So what will be the application? Some technologies, if I think, for instance, more of pharma, if they think of COVID, the mRNA technology can be used for many different applications. So you would also define very specifically what you're going to use the license for. The broader you would be your license in terms of the field of use, the more you need to pay. So you want to be, as a licensee, you want to be really specific because it will affect the price, it will affect the royalty that will be imposed upon you. Also, the access and user rights. What will you be using it for? Will you be producing yourself? Will you be distributing? Will somebody else, will another company be distributing? So all of that will normally be specified in the licensing agreement. Also, as a licensee, are you allowed to sub-license to others? So that is quite common if it is an exclusive license. So if you are the only person who can use the technology within that territory and for a particular application, then often if you have an exclusive license, you may also be sub-licensing. But in case of non-exclusive licenses, often you will not be allowed to sub-license. Does that make sense to you? So and why does that make sense? So what is the difference between exclusive and non-exclusive license? Why wouldn't you be sub-licensing with a non-exclusive license?
Yeah, because the company that gives away the license has an interest to give the licenses to the different undertakings, and not that one undertaking gives it to the other because they get more cash.
That as well. But of course, in theory, if you give an opportunity to sub-license, you could also get money indirectly. But the problem is if you have many non-exclusive licenses and those non-exclusive licenses are allowed to sub-license, it becomes a mess. And there's a chance that there's a lot of overlaps and that you would actually enter into problems, and that it's really difficult to still oversee and to monitor what's really happening. Because of course, also what you want to do as a licensor, as the IP owner, you want to be able to have an overview of who's using what, so that the royalties that are being paid, that they're correct. And that becomes really difficult if you have a lot of non-exclusive licenses, even when it's for a very specific territory. If they can then also sub-license, that type of control becomes really hard. And this is also why in the license, you will normally also find reporting requirements. So there is an independent expert, an accountant that is appointed by the licensor that will go to the licensee, will look into the paperwork, will look at it depends whether it's accountant on the basis of the sales, the revenues, that all will be decided in the specific license. And so then on the basis of that, there will be a calculation made of what needs to be paid. Also, if the license doesn't only cover patents, but also know-how, there may also be provisions about the assistance. Because of course, know-how is just generally not something which is written down. It's in the head of the people. It's the experience, the expertise of the people at the working for the IP owner. So what you then see is that often there's an exchange of employees, or there's some other arrangement in terms of technical assistance, which would be included also in the license. Another important aspect are the milestones. So there will be milestones included in the license. So if a particular number of products has been sold, then that may be important for the licensor, because he of course wants to stimulate the product from being used, from being sold. And so maybe the royalties will be lower when that milestone has been reached, or maybe the milestone needs to be reached because otherwise you may lose your exclusivity. And so there may be all kinds of restrictions may be attached to those milestones that are imposed. And then another quite important provision are the grant backs. And maybe you remember from last time that Miguel also explained that in the technology transfer block exemption regulation, it is specified that exclusive grant backs are forbidden or are an excluded restriction. So they're not a hardcore restriction, but an excluded restriction. You know that in the block exemption regulations, there's the distinction between hardcore and excluded restrictions. So what are excluded restrictions? What's the difference between hardcore and excluded? In the past, we also sometimes made the distinction between black, gray, and white. But the colors are no longer so in fashion. So what does it mean, an excluded restriction? I see, Sonia, you have your hand up. Is it because you want to stretch, or I teach a lot in a hybrid manner, so I always try to include also people who are participating online. So Sonia, do you have an idea what is the difference between the hardcore restriction and the excluded restrictions?
Yeah, so a hardcore restriction would take you outside of the block exemption. So the block exemption wouldn't apply at all. And an excluded restriction would mean that that particular clause of licensing agreement wouldn't gain protection.
Yeah, and so if I remember correctly, I think in the text of the block exemption regulation, and Valerie has also sent you the technology transfer block exemption regulation, also the guidelines. You find this in Article 4 and 5. So in 5 are the excluded restrictions, and there is a provision also on grant backs. But so grant backs as such are not a problem. It's the exclusive grant backs that may be problematic. So who knows what a grant back clause is? Now I go to the back. Do you know what a grant back clause is? And why that it is good or bad, desirable, problematic?
Should know, but I can't explain right now.
So who would be granting something back? It's already in the name. So somebody is granting something back to somebody else. So who is granting to who?
The licensee is granting back to the licensor or something.
Yeah, because the basic license is about the licensor is granting a license to the licensee for a particular scope and under specific conditions. But in this grant back clause, there is the provision that the licensee will license back to the licensor. So in what kind of circumstances could that be important? And again, these are not very difficult questions. It's just common sense. I just try to involve you a little bit more than just lecturing.
If the licensee itself has something that is interesting for the licensor.
Mm-hmm. Could that be whatever that the licensee has in-house, something unrelated, which the licensor would find interesting?
No, it's really related to the license.
Yeah, it's generally an improvement. Huh? So if the licensee often will still do something with the patented technology, generally it will not just be simply produced. There may be the product may be further improved with some different ingredients, depending, of course, on what type of product it is, or if it's some kind of construction material, maybe to make it stronger, or to add some components to make it more circular or more sustainable. So that could be, it could be in the interest of the licensor to also have access to that improvement. So it makes sense. If the licensor would not have access to those improvements, it's possible that they would no longer be competitive themselves. Maybe they would be outcompeted by the licensee. That's of course not something that you want to have as a licensor. So that type of grant back provisions are really very common and also logical, and they're also useful to further to stimulate licensing, because if you wouldn't be allowed to have a grant back clause, probably a lot of licensors would not want to license out because it would be too risky. If somebody would improve upon it, they would not really have easy access to those improvements. So why is it mentioned as an excluded restriction? What is important there is that the word in front of it, it's an exclusive grant back or a non-exclusive grant back. So exclusive grant backs would be considered problematic because the licensee would be obliged to license it back exclusively to the licensor and would not be able to license it to others. And so that would be too big a restriction on competition and also too big a restriction on the licensee itself. So just really to emphasize that grant backs in general are very common, are also logical, and would be good and are understandable that they exist because of the whole idea of IP, which is to stimulate innovation. But it really depends whether you do that on a non-exclusive or on an exclusive basis. Okay. So if we then go to this license and we look at the provisions here. So where do we find the grant clause? And what is the material and territorial scope of this particular example? So, Simon. Do you have time to look at it?
Yes, I have time, but I just wanted to precise which agreement we are talking about. This is because we have two.
Yeah, the widget one. So not the Philips DVD license, but the other one on widgets between Norman and Acme.
Article 2.
Mm-hmm. Yeah. Article 2 is the grant clause. And so what is being licensed, or what kind of license is it? Is it exclusive, non-exclusive? What is it? What is the scope? It's exclusive, yeah. And what is the scope? Territorial or the material scope? Or where do we find it? Yeah.
It's worldwide or anywhere in the world. It says in 2.1, and it's the right to make for others, have made, use, sell, offer for sale, import, or otherwise distribute products.
So those are the specific rights. The access and use rights are what you're referring to now. And so the fact that it's global, that is the territorial scope. We know that it is exclusive. So it means if a license is exclusive and also global, so you give away a lot of rights. Huh? So that means that you can expect that the royalty is pretty high. Because an exclusive license means that also the licensor, him or herself, is also not allowed to use it. Huh? So a lot of people think that exclusive means that it's the licensor and the appointed licensee. That's not correct. Exclusive means the licensee, only that licensee. And so what you often see is that you would have an exclusive license, but for a particular region, that company A or licensee A would get an exclusive license for Europe, licensee B would get an exclusive license for, let's say, Australia, Asia, and so that there's some kind of regional exclusive licenses. But Acme gets an exclusive license for the whole world for a very broad access and use rights. So you can imagine that the price will be accordingly. And what is the material scope? Simon, I leave that to you. I go back to you. So what kind of products?
Rust-proof widgets sold by Acme. So this is.
And so where do you find it? In which article do you find it?
It's free.
It's yeah, of course you find, of course, the widgets you find mentioned all over the license, but where is it really specified? What is the exact material scope? And which patents are granted, or is there maybe also know-how which is covered by this license? Where do you find that? Do you find that in the grant clause as well?
So the definition?
Exactly. Yeah. Yeah. So in the definition, where do you see that? Yeah. So you have defined the widget itself, and then under 1.4, there's also norm information. So if you read that, what does that mean? What is information? Are there intellectual property rights to information?
It's intangible.
Uh-huh.
So usually not, I mean, I would assume that that's the know-how that you were talking
Yeah,
about.
but the way it's defined, it's quite broad. It's also, it's equipment, facilities, but it's probably also the knowledge about how to deal with that equipment. So I would see it indeed as know-how. And so the 1.4 shows you that also know-how is being covered. And so under 1.5, you then find the definition for the norm patent rights. And so if you check that, so is it only patents or also applications? And where do we have patents? Is it in Europe, US, China? What is listed there?
There's also applications,
Mhm.
and it's also in the US. It shall include the US
Yeah.
applications.
Yeah, so it focuses here on the US and patent applications in the US, which are then also listed in Schedule B. And also we have seen under 1.4 that in Schedule A, so the annex, there is also a specification of the know-how which is covered. And so under 1.5, you have also an annex relating to the patent rights. But is there more than just US patents and patent applications? Are there also others which are being covered?
Foreign equivalents.
Exactly. And so probably the first patent was filed in the US. And maybe you remember also from last time I mentioned this priority right. So often what companies do is they will file first in their home country because they know the procedures well. And also in the US, you don't have to file translations. It's not not as complex as in Europe. So often they will file first in the country where they are located. And then they will have the filing date. And this filing date is determinant for deciding whether something is novel and inventive. So it's the determinant date for looking at the prior art. So it's very important, this filing date. And with that first filing date, on the basis of the Paris Convention and the priority rights provided there, you can also apply in many other countries. And it will be that first filing date of the US that counts. So that is really beneficial. It's a very important right in practice. So basically the foreign equivalents are the rest of the patent family that were applied for later. And it's quite likely that those applications are also, that there's still some applications pending there too, but that will be specified in this annex that we don't have, but that you know it. So we know there are US rights, there are some foreign equivalents, but we can assume probably not in all countries. And still the license is global. Is that surprising? Or do you think it makes sense? Because you may only have territorial rights in some countries and not everywhere, but you are paying for a global license. So is there something else which is very valuable that you're licensing?
When you're saying you might have
As far as I remember, it was exclusive.
It was
so
exclusive.
No other company will have the right in any other country of the world.
Yeah. So that is very valuable.
That's valuable.
But does it mean you also want to pay for a global license if you would only have rights in US, Europe, China, and you're paying also for Brazil, India, Iceland, I don't know, all countries in the world. Does that make sense? If you only have patent rights in those listed in the annex? What do you think? Yeah, I can only see Vivian, Simon, and Sonia, but I assume there's more people participating online.
There is some of them left for this session.
Okay.
It's somewhere.
But there are many more people
Yes,
registered for the course, but for today, there are not so many.
On that to have.
Okay. It sounds.
That's the reason why.
Okay. So Vivian, a global license, even though there are territorial rights, does that make sense to you?
No, I don't think that makes sense because they do not have registered the patent. For example, in China, how they can license the patent. How can they license something doesn't valid? So I don't think that this makes sense to give.
Who agrees with Vivian that it doesn't make sense to have a global license if you have only territorial rights in certain countries? Who says that doesn't make sense?
I was wondering if I understood you right. Are there countries that do not protect IP rights?
But so here, I mean, it would be the strategic choice and not to apply for protection everywhere. So imagine that in the annex, you would not find rights in all possible countries, but just in a number of countries. And of course, that's up to the IP owner to decide where they want to protect.
But in all known or appreciated countries' legislation, we have some protection for it.
At least in all WTO members, because there's a TRIPS agreement, so they are obliged to have at least some IP protection. And of course, a lot of countries are a member to the WTO.
But I think in that specific case, they asked a question on it. It would make sense since licensing agreement also probably contains the right to file for a patent. So it will be subject to the licensee's decision if he then maybe wants to.
And there is the know-how. No, the know-how has no limit. The know-how is protected as long as you keep it confidential. So the know-how is global, even though the patent rights will be territorial, provided that, of course, in each country there is protection for trade secrets. But again, if you're a WTO member, there will be some kind of protection also for trade secrets. So there is nothing anti-competitive. So some people believe that it would be anti-competitive to have a license with a global scope if you only if you would relate only to patent rights, but even that is not necessarily anti-competitive. It's also something that Miguel mentioned last week. Okay, so what else do we want to see in this license? So we have the type of license, the territorial scope, the material scope. What about the reporting requirements? Do you find them here too? Or maybe we first say, so where do you see something about the price? Where do we see the price? What is Acme paying?
2.3.
Yeah. So there you have the scheme and the table with the different steps. So basically you have some kind of milestones there that are achieved, and then the royalties will go down. The more you sell, the lower the royalties for on the basis of the net sales. And then reporting requirements. So I will help you. You see that also in Article 2, but under 2.7, 2.9, and in 2.9, it's then also specified it should be an independent auditor, certified public accountant. So those are really very, very common provisions. You still then have also a provision on the confidentiality, the fact that also the information that Acme shares with Norm, that Norm has to also keep that confidential. That will often be very sensitive business information that you don't want to share very widely. And then also very common, the warranties and representations that you see under Article 4. And so Norm warrants that there are no claims of third parties contesting the validity, enforceability, and the ownership. So that's quite important. If you take a license, an exclusive license globally, you pay high royalties. Of course, you want to have at least some kind of assurance, a warranty that those rights, that at least there are no pending claims, that there are no pending challenges, and that there have not been any notices of infringement, which you find under 4.4. Then under Article 5, that's also quite interesting. There you find that in case there would be and also the following article, in case there would be further prosecution of patents and the applications, and also in case of litigation, that this will be, that the initiative is with ACME. So Norm is the IP owner, Norm is the licensor, but in the next steps, it's really ACME that takes the responsibility. In case another company would be infringing on the rights, ACME is taking the responsibility, and the initiative will also get a lawyer for that procedure. Does that seem logical to you? And if so, why or why not?
I mean, I think it's logical because ACME has an interest that the patent rights are being upheld, because then they keep on being the only ones allowed to use it. If a patent is going to be declared invalid, then everyone else could also use the technology.
Yeah. So ACME actually has a bigger interest because it's an exclusive licensee. So for most non-exclusive licenses, that wouldn't be the case. It would be still the licensor who wants to keep control. But if it's an exclusive licensee, so Norm can no longer use the technology itself. It's just getting the revenue from the royalties. But for the rest, it is really much more in the interest of ACME that, and Norm will of course collaborate. There's also a collaboration obligation on Norm to ensure that all the required information in terms of the patent filings, the original patent filings, that will be shared. Okay, are there, yeah.
There's also in Norm's interest that the patent is being upheld because they are getting the royalty from it, and if it's declared invalid, then they will not earn anything from the patent. So.
Yeah, so that's also why it's logical that there will be collaboration anyway. So it's not in the interest of Norm not to collaborate, but actually ACME is depending for its whole products on the license, whereas for Norm it's more of it's a nice income, it's a nice extra, and probably it allows them to innovate in another field or to work on other types of products, but they're not as dependent on it as ACME will be. So there's an interest from both sides, but to do it really well, probably a little bit more from ACME. Are there other comments or questions on that? No? I think it's really so strange that there's so few people. We never had that before.
No, I don't.
I never had that before, even when there would be another exam. It's quite remarkable. So I'm even happier that you are here. And I think, are all of you not located in Brussels? You're all coming from other places, or you are from Brussels? Or?
No,
Albania. Ah, you see, so you made the whole effort of coming here, and then others who could participate online are not even participating online. Okay, very, very interesting, very interesting. We need to do some research on that.
I will send you in on Monday.
Yeah, for me, it doesn't matter. I rather focus on the people who are here, but I find it quite fascinating. Just going back to, so what is determinant for the price, for the licensing fee, for the royalties? So that will depend, are these old applications, or are there already a lot of granted patents? Is it a pioneering invention? So last week I also made this distinction between more incremental and more radical innovations. So if it's really a pioneering invention, of course you are willing to pay more, but then often it will also not be an exclusive license. It's more likely that you will have a non-exclusive license and that others will have licenses for other applications in different fields of use. So also, how broad is your field of use? What is the scope of the patent? What is the maturity of the technology? If the technology is already 12 years old, probably you will also be paying less, unless it's, of course, a very core platform technology. It may still be really, really relevant. So what we looked at was a bilateral license, so relatively simple. You have two parties. What you see in more and more situations, and especially also in a sector like the telecom sector, consumer electronics, there's often a lot of competitors all innovating, all trying to get patent protection. So you see a lot of cross licenses. So where both parties do have patents that they own, and they both have an interest in getting access to the patents of the other party. So this is, you see this in different sectors, different industries, these type of cross licenses, and not just the more simple bilateral license that we just looked at. Then also here, this is the example of a patent pool. So where you have actually more than 2 IP owners, and not everybody who's interested in getting a license also has patents that could be licensed out. So what is happening then there? The important IP owners who are willing to step in such a pool, they sit together, they decide on a pooling agreement. So under which conditions are they willing to license to each other, but also under which conditions are they willing to license to third parties. So basically you have 2 agreements. The pooling agreement between the different IP owners and the third-party license to those parties that don't have any relevant patents, but that do have an interest in getting access. And those third-party licenses will, of course, all be non-exclusive because there's many of them, and they may have different territorial scope depending on their needs and where these companies are active. But so these patent pools also, so the cross licenses are common in the standard setting environment, but also these patent pools. So for instance, with respect to the MPEG standard, that's already a slightly older standard, but also with more recent standards, also the 3G, 4G, also within the context of Internet of Things, there are some patent pools that are being set up. And so in the past, this MPEG-2 pool was very successful. So when companies were sitting together to set the technological standards, those same companies were seeing, oh, there will be a lot of patents here, and we will all have an interest in getting licenses. We need to simplify this because otherwise the costs of negotiating, the cost of the actual transaction costs would be too high. So that was yeah, let's say already quite a while ago. I think it was in the 70s, 80s. And so then, so the companies doing that, they all decided to set up such a pool. And so also in the later years, no, it was in the 90s. It was not that long ago. It was in the 90s. And so also the following years, a lot of those pools were being set up successfully. But the reason why it was so successful was also because all or most of the patent owners also needed access. So there was a lot of homogeneity. There were the same interests. Whereas now you see more and more cases where there is some willingness of the patent owners to step into such a pool. But there is a much more heterogeneous environment. So you would have companies such as Qualcomm that have a lot of essential patents. And then you have companies that normally were not at all involved in standard settings, such as, for instance, car companies, that because of the smart features in cars, now also need access, need licenses to those patents. And so these are very different profiles. They have very different interests. And so it's now also much harder to have bilateral licenses because of these different interests and concerns, but also the pools are no longer as successful as they were in the past because you have such a big variety of players. There's still some that are being set up. There are also still some new pools, but in the past it has been easier than that it has been now. And there's also much more litigation also against some of those pools, more than we have seen in the past. And so, so this is quite an important, even though it may look a little bit exotic, these type of patent pools, in particular sectors, they're quite common. And also there was a concern that because often the patent owners are competitors and they step together in such a pooling agreement. So competition authorities had something like, oh, this is tricky because these are competitors sitting together. We need to be very careful with this. And so already in the 90s, there were guidelines that were being set up, specifically also related to those pools. And in the US, there is a procedure for business review letters. And so if you set up such a pooling arrangement, you could ask the Department of Justice, you know, with all these different features of this pool, is this okay? Is this in line with antitrust law? Do we maybe need to change certain things, or is it in compliance? And so those business review letters are also very valuable. They're still the old business review letters for those older pools, but also for more recent pools. This mechanism has been used to check the compliance. But so also in the technology transfer guidelines and the TTG of the EU, there's also a section on patent pools, and we will come back to that towards the end of today. Oh, is it already that late? Okay. And we will look at the other license, the DVD license in that respect. So this we have already seen. So these are other kinds of provisions that you have in the license. So reporting requirements, different warranties, the applicable law. So these are more the typical kind of provisions that you have in contracts anyway. So a few words on compulsory licensing, even though this may seem more academic. But so Miguel also a few times used the word compulsory license. So the case law related to McGill, IMS Health, where under the exceptional circumstances test, you have these criteria under which companies are not allowed to refuse to license. So if a competition authority then says, if you refuse to license, that is anti-competitive, and hence you are obliged to license, that is then a kind of compulsory license, but a compulsory license according to competition law. We also have compulsory licenses in IP law. So in national patent laws, you find provisions that say that in, again, very specific circumstances, so comparable to competition law, in very specific circumstances, it is possible for a judge, and this may be a patent judge, so not a competition authority, or a minister that is competent in the area of health. If, for instance, we're looking at a pharmaceutical company that is refusing to license. So in very specific circumstances, a judge or a minister can say, we will grant a compulsory license. But so it's important to understand, so you have that according to the case law that Miguel has discussed, IMS Health, McGill, all those cases, Microsoft, and we also have it in IP law, in patent law, and so the procedures are different. But the instruments are also basically complementary. Sometimes, if there would be indeed a pharmaceutical company that refuses to license, so you could challenge this, or you could complain about this with the competition authorities, or you could go to the Minister of Health and ask for a compulsory license. These are two complementary mechanisms, but both they apply in very specific circumstances. It's not that companies are doing this all the time, because you can imagine that a compulsory license is also kind of contradictory to IP law, because normally it's really inherent in the rights that an IP owner has, that he can refuse to license. So in all normal circumstances, an IP owner can say, yeah, no, I don't want to license to my competitor. I don't have an interest in doing so. Even when this competitor offers to pay really high royalties, if you don't want to do that, in most cases, that's fine. That's normal. That's what you can do because you have a right to exclude. But in very specific circumstances, according to competition law, case law, and according to the national patent law, for reasons of failure to work, public interest, national emergency, extreme urgency, pandemics. So a lot of countries have also said, within the context of COVID-19, we think about granting compulsory licenses if companies are not willing to license, are not willing to allow others to produce these vaccines. Did they do it? No. Otherwise, we wouldn't have had the situation where in a lot of countries, they wouldn't have had access to vaccines. But countries said they would do it. And the EU also said, and there was then all this discussion about the waiver of TRIPS obligations, and maybe you have also followed that. That's at the level of the WTO, where India and South Africa said, okay, maybe we should completely waive all intellectual property rights for all IP related to COVID-19 vaccines, protective equipment, the masks, treatments, diagnostics. So that discussion started in fall 2020, and they still didn't decide. They couldn't agree under which conditions such a waiver would be applicable. But so the waiver is not the same as a compulsory license. The waiver would be at the global level, and I would say, okay, for these products, everything related to COVID-19, the rights would be completely waived. It would not be possible to enforce your rights, even when you would have them. Compulsory licenses is on a case-by-case basis. A judge decides this particular company is compelled to license to this particular other company under these conditions for this license. And so very specific, very exceptional circumstances. So even though, again, the waiver could be useful, a compulsory license too, but you need a lot of compulsory licenses in a lot of countries to achieve the same thing as what a waiver could achieve.
Talking about waivers, to which extent would that be in alignment with Article 17 of the EU Fundamental Rights Charter, which says that even intellectual property will be protected?
Yeah, I think there are a lot of arguments that people invoke against having such a waiver. And indeed, protection of property, and protection of property also covers intellectual property rights, is one of those arguments. Another argument is waiving these rights doesn't really help, because you also need access to the raw materials. So just saying, okay, you cannot enforce your rights does not give you access to raw materials. Also, it's really difficult to get access to know-how if the know-how holder is not willing to share it. Because you just keep it secret. So a lot of people say we should rather try to get a collaborative arrangement. So also within the context of COVID, they try to set up a pool and try to convince companies to step into the pool as a more voluntary mechanism in comparison to compulsory licenses and in comparison to the waiver. But the pool was also not very successful. So it has been really quite problematic. But so just to show you that there are the compulsory licenses according to competition law, the case law, really important. That's what is the focus more of this course. But in IP law, we also have such instruments. And then there are even further going instruments, such as a waiver, which is still being considered.
Question to the compulsory license. Does that mean the compulsory license is granted from one licensor to one particular licensee? Can there be third parties also applying for the same compulsory license, saying if this company got the compulsory license, I also have to get it?
Yeah, so the judge or the minister, it depends on how it's written in national patent law, will need to decide for each case, for each application for a compulsory license, will it be granted? And a compulsory license will always be non-exclusive. So in theory, you could have several non-exclusive licenses, and those licenses do not necessarily have to be exactly the same. Maybe a slightly different application, different territorial scope. That would be then decided by the judge, but not decided by the IP owner. And that's, of course, what makes it remarkable.
It has to be decided in every single case.
Yes, upon application. There are some countries where the procedure is slightly different and they have a more broader sort of statement. Okay, we will grant compulsory licenses, come to us. So, and then you would have more of a kind of procurement system. But in most EU country, most European countries, you would have a system where it's really on an individual basis. But if you're interested in this, I could send you an article that we wrote about it. But now I want to go on to also look together at the DVD license. So I still have a lot of slides, but I think a lot of the slides you could also go through, and I want to focus more on the practical part. But so I want to mention to you that also the technology transfer guidelines, together with the technology transfer block exemption regulation, they clarify to you what kind of clauses can you have in a licensing agreement. You have also similar guidelines in other countries. So in the US, you have IP licensing guidelines from 2017. Also in Japan, guidelines for the use of IP. And all those guidelines are relatively similar, luckily, because it would be very strange if you would have a global license agreement and you would need to adapt it and tailor it to different jurisdictions. There are some differences in terms of details, but most of it is quite similar. And then I mentioned before these DOJ business review letters, that if you are working in the field of IP licenses and you have a more advanced or complicated licensing arrangement, it could make sense to ask the Department of Justice to issue such a business review letter. So that is also still something. And in Japan, they have something similar. You can ask for administrative guidance on a particular agreement, on a particular setup or collaboration. And that could be helpful if you're uncertain about the compatibility with antitrust law, with Japanese competition law. In Europe, we had that, but we no longer have it because the Commission said it's too much work. We cannot do it. So so in Europe, it's up to the companies to make that assessment yourself. And you have to do the kind of economic analysis that involves yourself. And so there is some legal uncertainty in that respect. And so what you need to do is basically deciding on the compatibility with the criteria in 101.3, and that is specified then in the block exemption regulation together with the guidelines. And especially the guidelines are really quite helpful. So I will go over this because all of this was also mentioned by Miguel, but this I want to specify. So we now have the version of 2014. So the block exemption regulation and the guidelines are from 2014. The previous version was from 2004. What you see with other block exemption regulations, the horizontal one, the vertical, every time it's quite controversial if there is a review. So they check, has it been working well? And they try to improve, they try to strengthen, they try to create more legal certainty. And often there's a lot of criticism on the text of the regulation and the guidelines. This has been quite different for the technology transfer guidelines and the block exemption regulation. If you look at the text of 2004 and 2014, not so much has changed. And so on the following slides, you see some requests that were made, for instance, on clarifying the scope of application. So for instance, it was not so clear whether R&D collaboration agreements, whether they would fall under the technology transfer guidelines or under another block exemption regulation. So that is clarified in the ones of 2014, they're out. If there is a license involved, then it's really the TTBR, which would be applicable. Also, there was some discussion on changing the market share. There was some discussion on changing the provision in Article 5 on the non-challenge provisions. And also equal termination clauses with that. That was also not modified. So here you find some examples of things where there were suggestions to change. So for instance, also all exclusive grant back clauses would be, so there has been a slight modification. And also with respect to patent pools. So in the past, the third party license was subject to the block exemption regulation, and the guidelines were dealing with the agreement between the pool members. So you remember the image. So the pool agreement would be under the guidelines, and the license, the third party license on the right was under the block exemption regulation. So now that is also clarified that all of that now is discussed under the guidelines. There's much more details than, of course, could be done through the block exemption regulation. And because a pool is such a special kind of arrangement, they thought it was better to deal with that in the guidelines in more detail. And so, yeah, you could say that the block exemption regulation for technology transfer and the guidelines are quite successful. And there haven't been so many complaints. So even though still some people say, yeah, okay, every time it's still difficult to decide on the compliance, doesn't give us absolute legal certainty. And it would be nice if we could sometimes ask the Commission and indeed have something like the Department of Justice business review letters. but at least it is already less controversial than some of the other block exemption regulations. This is, and as I said before, and Miguel also last week, generally licenses are considered pro-competitive. It's only very specific provisions that would be considered problematic, but most of it is pro-competitive because what you do is you actually facilitate diffusion. You disseminate your technology if you're licensing out. So in most cases, that will be good. And if you have small restrictions, that will be fine. Often you will be able to justify it also for reasons of stimulating innovation. Weighing those pro-competitive and anti-competitive effects, so small restrictions on the free competition are not necessarily problematic. And so you make the normal analysis, like Miguel also explained last week, in terms of the inter-technology impact, the intra-technology impact, and some restrictions may be objectively necessary. What you look at is whether in the absence of the agreement, what kind of level of competition would you otherwise have had? And those kind of assessments are not necessarily so easy. And as I said before, if you need to define the market and the market share, that is not necessarily easy in those innovative markets because they are so volatile, because they are so dynamic, and it's changing all the time. But yet, in practice, it is feasible, is what I have heard from most practitioners, because I'm an academic, so I'm not really doing that kind of advisory work myself, but I do a lot of interviews with people to actually get a taste of practice. So if you look at the block exemption regulation, of course, we would always look at the scope of the regulation. So what is covered? Know-how, patents, supplementary protection certificates. Miguel explained before what those SPCs are, especially relevant within the context of pharma. We will talk a little bit more about it next week. But not all copyright. So only copyright related to software, because it relates to technology rights. So if you have a software license, then it could be covered. It could be related to patents, software, computer implemented inventions, could relate to know-how, and could relate to copyright, but music copyright licenses will not be covered here. So that is important. So not for all licenses will the block exemption regulation be relevant. So check the scope if you would be looking at this. So I think I have already said quite a bit on defining the market. We still have 10 minutes. Market shares, there also Miguel has already made some further statements. The hardcore restrictions, so the black clauses, as they may be referred to, are also the more basic ones. And so this is what I would like to deal with you for the last 10 minutes. So going back to these patent pools, as I said before, these are quite common within a standard setting context. I have already explained how it works. So the pooling agreement together with the third-party licenses. And I have explained to you that according to EU competition law, you have to look at the guidelines because there it's specified what the pool should look like. And so there are a couple of criteria, a kind of roadmap that is set out for patent pools in the guidelines. And so all the patents that are put in the pool need to be valid and essential. So, as I said before, it's not always so certain that patents that are granted are also valid. So who decides whether the patents are valid? That is quite important. So generally, it will be the patent office in an opposition procedure, because if a patent is granted and you are a competing company, and you don't agree, you think the patent should never have been granted, then you can go into opposition before the European Patent Office. Or you can also go to court and challenge the validity of the patent in court. Or if there is an infringement procedure which is started by the patent owner, then you can have a counterclaim saying, okay, you say I have infringed your patent, I say this patent should never have been granted in the first place. So validity can come up before the patent office, it can come up before the courts, but it is also relevant in a pool. Because if you would have a pool with maybe, I don't know, 900 patents, 900 or 999 relevant patents, then it's important that this big bunch of patents, that you can be certain that they're really reliable and that the risk that, let's say, 800 of them are invalidated is not too high. So this is why there is the requirement, according to competition law, that there's an independent expert, a patent attorney in most cases, who would judge all the patents. And so what will happen? So the patent owners that want to step into this patent pool, they will need to give an overview of all the patents that would be relevant for the standard and that they think could be licensed out through this pool. And then often there will be an organization that has a lot of experience with pool administration. So there's, for instance, MPEG LA. There's also CISVIL that you might have heard of. They are also quite involved in several litigations. So what happens? They have those independent experts that would then do the analysis. They would be independent. It's not a patent attorney working for one of the IP owners. No, it's an independent one. And also the validity and the essential nature of the patent is dynamic. So it also needs to be updated. It's not that one time the patents will be evaluated. No, also later on there will be a reevaluation because maybe they are invalidated in another procedure and then they would need to be dropped from the pooling arrangement. Also, what is important is that the pool is not a closed model. So if initially a particular patent owner is not involved in the setup of the pool, they should still be able to step in also later on and add their patents to the pooling arrangement. Also, there cannot be an obligation to license from the pool. So imagine there is this MPEG pool that is being set up. But you will not need access to all the patents that are in the pool. Then you shouldn't be obliged to get a license from the pool because your price would be much higher. The royalties that you need to pay are higher than what you need because maybe you only need 20 of the patents out of the 999 that are in there. So you could still go also beyond the pool to those individual patent owners. Then you don't have the benefit of saving transaction costs because you have the whole package through the pool, but you will only be paying for the patents that you need. And so from a competitional perspective, that's really important that you're not forced, because that would be an example of foreclosure also of the market. So licensing out of the pool, that is also a requirement. And the royalty will be set by the pool, and the royalty also needs to be friends. So there we're back to fair, reasonable, and non-discriminatory terms. And you've heard also from Miguel how difficult and controversial it is to actually decide what is fair, what is reasonable, and what is non-discriminatory. So this has also been an issue for the pools, but the advantage is that in comparison to the cases that Miguel is discussing, there it's a one-on-one situation. So it's logical that the licensee will not agree with the licensor. But here it's a whole group, which on the one hand makes it harder, but it also makes it more democratic to decide on the price. And there is often this independent pooling agency that is also involved in the arrangement of the pool, so that may also help. So basically, this roadmap is a kind of safe harbor that you find in the guidelines. So if in the future you would be involved in such a pool, it really will be helpful to look at that roadmap and guidelines, or depends where, which jurisdiction is relevant, looking at the guidelines of the US or Japan, because there you also find some provisions on these pools. But again, very similar to what you find here. Except for the more institutional arrangements. So EU competition law has some further requirements also as to how the pool should be set up, that there should be also some kind of independent dispute resolution mechanism, which is not really competition law. So I understand that the Commission likes to see also some kind of ADR mechanism included in the pool, but it's not really an obligation coming from competition. But they did include it in the guidelines. What you also see in terms of the requirements, so France terms, non-exclusive grant backs. So we have seen how important it can be to have such grant backs. But if the pool would impose exclusive grant backs, of course, that would really foreclose the market, because then you would not only be obliged to license back to one, but you would be obliged to license back to the pool, and you would not be able to license to others. So that is not really compatible with the logic of competition law. So we still have a few minutes to look at the license that I gave you. So this Philips license. So what does this relate to? Is this a pooling agreement? Is this more of a third-party license? And who are the patent owners that are relevant here? So Vivian or Sonia, do you want to say something? So what type of license is this within the pooling context?
That is a patent about the DVD audio system. The owner is the Sony, Pioneer, and Philips. Yeah. And what does it relate to? So what is the material scope of this license? The scope is about a non-exclusive. Yeah, so the one of the conditions is that it's a non-exclusive license, which is important because it's a third-party license. So it's not the pooling arrangement, but it's the third-party license to other parties. So Philips, Sony, and Pioneer will also have an agreement amongst themselves, and Philips basically got the authority to act on behalf of the others. So that's also clear from the heading of the license. And so this license, because it's a third-party license, it needs to be non-exclusive because you can have many different licenses. But what is the scope? So you mentioned it's DVD. But so is the context specific, or is it just DVD patents that Philips, Sony, and Pioneer have? Why are they working together? Why are they setting up this pool? That is about the DVD audio standard specifications. Yeah, exactly. So again, you should look at the definitions. So you see that the scope is for DVD audio players, DVD audio disc, and there is a DVD audio standard specification. There are already several versions. So it's again in the standard setting context that this pool was set up. But it's only with 3 patent owners. So as I said before, there are many examples of patent pools with many more IP owners. So this is a relatively small pool. And Philips has a lot of experience in administering pools and doing a lot of licensing. They also have a really big licensing department. So this is also why it's kind of logical for Philips to take the lead in this licensing activity. So, and where is the grant clause here in this license? Oh, yeah, and you already said it was non-exclusive, so basically you already found the grant clause. Which article was that, Vivian? Article 2. Yeah. And where do you find the most important licensing conditions? So if we look at the specific criteria that I have just listed, that this roadmap, this safe harbor that you find in the guidelines, do you see any wording that you recognize from those guidelines? Yes, in 2.01, the safe harbor that is non-exclusive, and I noted in 2.02, the safe harbor is on reasonable and non-discriminatory conditions. Yeah, there is also another safe harbor. Yeah. And do you also find something about the grant back?
Vivian or somebody else?
Yes, I find it at the 2.04. That
Yeah.
is non-reciprocal cross-licensing the grant back.
Yeah. And so it is non-exclusive, so that is in line with the roadmap. I would be surprised if this license would not comply with the roadmap. I couldn't find an example. Of course, I could make up an example, but this is a real one, so I think it works better. In terms of the licensing fee or royalties, what do you find there?
The Article 4 is about the royalties.
Exactly. And so also here you will also find reporting requirements. And then towards the end, you also find, do you find something like a termination or a challenge clause, a non-challenge clause? Yeah, so there is a termination clause. So this is the only thing where I think this is a little bit tricky, because actually pools also, there needs to be a space to challenge the validity of the rights, because actually what is a requirement is that all the patents in the pool that they are valid and essential. So if you then include a termination clause that basically prevents a company from challenging those rights, controversy also within the context of the block exemption regulation. Non-challenge clauses, they don't really want to have, but termination clauses can be okay. So here this is, in my perspective, the only more, the provision that would which I would do differently, personally. But of course, I'm looking at it from an academic perspective, also from a societal public interest perspective. So I can understand, of course, also from the perspective of the IP owners, that they don't really want their licensees to actually challenge the patents that are the core of the license. So I think the way that it's written is there's some caveats, there's some conditions, but ideally you wouldn't have such a provision. Okay, so I think we're still reasonably in time, even though we did some more practical work also this afternoon. But so I really tried to show you a little bit more of the IP licensing practice next to the explanation of Miguel of the hardcore case law on the abuse of a dominant position, and trying to go together through a license, even though these are, I acknowledge, relatively simple licenses, but there's only so much you can do in a few hours. Because for the 101, from a 101 perspective, this is really the most important thing that you can do. It's looking at the block exemption regulation, looking at the guidelines and the compliance. That's the day-to-day practice that is really most important for Article 101. And what I also really wanted to show you is sort of the IP equivalence next to the refusal to license cases in competition law with the compulsory licensing provisions, where also in patent law you do have a basis for that, but again, only in exceptional circumstances. And in practice, not a lot of compulsory licenses are being granted. Even though it might be justified, and where also there is a push from NGOs, NGOs that deal with access to medicines, not only in developing countries, also here, especially if you think about public health and the very high prices for medicines. Sometimes there is no alternative treatment and the price is 1 million. If that is, for instance, for a sick child, people are eager to do a lot of things, crowdfunding, etc. But you may wonder whether those prices whether that's still feasible and whether for the health budget, whether that's the right way to go. So also within the context of very high prices for medicines, there's more and more attention for the possibility of compulsory licensing and using it in a more effective manner. If you're interested in that, we've also recently wrote a study for the Belgium authorities, not in Dutch, in English, about compulsory licensing and a more effective use of such compulsory licenses, and it will be available, I think, half of June. So if you're interested in that type of topics or interested, especially in the pharma sector, it's definitely also something that I could share. So we will continue with more pharma next week, but also much more standardization. If you have questions in the meantime for Miguel or me, don't hesitate to send us an email. Our email addresses are on the slides, and otherwise we will see you next week. And so for my part, the pharma, we will also spend a lot of time on excessive pricing. So if you have a little bit of preparation time for next week, maybe you can do some quick searches, some reading on the website of the European Commission. There's some interesting cases there. There's, for instance, the Aspen case. So if you want to prepare a little bit, that's something that you could do. We'll also speak a little bit more on the AstraZeneca case that Miguel already discussed, and the settlement agreements. And also for settlement agreements in the pharma sector, there's a whole section in the technology transfer guidelines that deal with that. So that will be basically the plan from my side, and many more standard setting cases from Miguel's side. So see you next week online. That is also nicer in real life. So the lunch here is nicer than what I eat at home. Yes.